Değerli katılım.
Distinguished guests, distinguished participants. In relation to the project of strengthening the human rights of the victims of human trafficking in Turkey, we have organized the Anti-Human Trafficking Summit, and I would like to say welcome to the second day of the summit. After the first day, where we had very successful deliberations on 30th of July, during 4 different sessions, we will continue to evaluate the issue with different perspectives. So I would like to invite the guest and the moderator for the third session of the summit, which is the first session of today. The panel is going to be on the crime, the human trafficking crime and Turkish Criminal Code. And I would like to invite the Vice Dean of Tob University, Professor Olgun Değirmenci. After the moderator, I would like to invite the panelists, the member of the third chamber of the Court of Cassation, Mr. Yusuf Hakkı Doğan, Ms. Meral Gökkaya, who is the head of the Department for Legal Support and Victims' Rights from the Director General of Criminal Affairs of the Ministry of Justice, and the public prosecutor of the Court of Cassation, Mr. Rifat Sagut. Professor Değirmenci, the floor is yours. Thank you very much. This is the third session on the human trafficking criminal offense in Turkish Criminal Code. And before we start this session, we would like to thank the Council of Europe and the DGMM for giving us this opportunity. We have 3 distinguished panelists in this panel. I would like to give 15 minutes to each of the panelists, asking them to summarize their views. We have the member of the Third Criminal Chamber of the Court of Cassation, Mr. Yusuf Hakkı Doğan, and Ms. Meral Gökkaya, Head of Department from the Ministry of Justice, and Mr. Rifat Sagut from the Public Prosecutor of the Court of Cassation. Now I would like to leave the floor to Mr. Yusuf Hakkı Doğan firstly. 15 minutes, sir. I would like to greet each and every one of you. My name is Yusuf Hakkı Doğan. I have worked as a public prosecutor and chief public prosecutor for a long time, and I have been a member of the Court of Cassation for the last 7 years. During the period where I worked as a public prosecutor, I worked as an expert on human trafficking and migrant trafficking. After the enaction of the new Turkish Criminal Code, there have been a certain jurisdiction and authority given to the Turkish National Police Gendarmerie, and we provided the training to the law enforcement. I'm not going to be talking about the provision of the Turkish Penal Code per se, but I have been a public prosecutor for long years, and as a public prosecutor investigating this criminal offense, because these criminal offenses are committed by organized crime groups, I would like to give you brief explanations about the loopholes, and I will be mostly sharing my experiences with you. In Turkey, actually fighting and combating human trafficking has to exhibit an approach that is going to be victim-oriented and victim-centered, respecting the human dignity of the victim. And in the training activities that we delivered, the judges and the public prosecutors we trained were actually informed of the fact that this can only be achieved by a well-trained judge, prosecutor, and law enforcement official team. In 2005, when we started providing lectures to the judges and prosecutors about migrant smuggling and human trafficking, I remember the reactions that I received. And as I was the public prosecutor in Antalya, the evaluations were mostly to the fact that everybody is happy and everybody has exhibited a consent with this human trafficking due to prostitution, etc. And as a result of the activities, we have really improved the quality of the judges and prosecutors. But because of the 15th of July coup attempt, there was an important loss of the staff of judges and prosecutors. About 3,500 were dismissed from service. So the newly recruited judges and prosecutors really did not receive sufficient training at the level that I actually want, that is going to make them guide their investigation and prosecution in an equipped manner. This was not a training that was delivered. We also had the following problem in training. You recruit judges, prosecutors, law enforcement officials, police, gendarmerie, the Coast Guard. You train them, and then the person you actually train does not stay in that position. This is one of the main problems. When I was responsible for terrorism and organized crime in Antalya, we had a staff that was appointed from Shirnak, and he was appointed as a person responsible for organized crime. And my colleague said to me, I do not know anything about this issue. I did not conduct any investigation on this issue. I have no information. And we sat down together, worked together for 2.5 years later. He became one of the people who was really equipped to do this, but suddenly he was appointed to someplace else, and he wasn't given any task about organized crime or migrant human trafficking. Therefore, we need to have a new plan about this training. In relation to human trafficking that aims that is conducted for prostitution, when you look at the Turkish Penal Code, there is a very severe punishment from 8 years to 12 years. And according to the Court of Cassation practice, for each and every person who is submitted to human trafficking, the sanction is repeated. If there are 5 people, it's 5 times the service. There was a case in the Netherlands, Shaban Baran case, and I conducted the investigation. He got permission from prison and escaped from prison. He came to Turkey, and he was in a criminal offense, and he was detained in Antalya. And because he was sanctioned to 7.5 years in the Netherlands for 20 people who were trafficked, and in our case this was 160 years. So it might be abroad, but if there is any prostitution that is conducted for human trafficking purposes, then this is a criminal offense of human trafficking. If you endorse prostitution, this is also committing the criminal offense of prostitution. So think about 20 or 10 women. You encourage them for prostitution. According to our legislation, it's 2 years per person. And if it is intentional, it is increased to 3 years. So for 10 women, the sanction that you're going to issue is 30 years. Plus, if it's organized crime, they get a sanction for that. And if they have been exposed to human trafficking, they're also sanctioned again. Therefore, when we compare our legislation with the European legislation, we have a very severe sanction system. But what kind of a provision do we have? We receive a criticism as follows, that the qualified measures are not regulated. So when we actually look at the provision, in 2020, there has been an amendment about migrant trafficking with law number 7,369, and this was an amendment in the law. If the criminal offense is committed with more than one person together, it's increased by 1/2. And there is an increase of the sanction. The punishment becomes more severe. So at the core, we actually have amended Article 80, so we can say that if this has been a criminal offense committed as a group, as part of an organization, we can actually increase the sentence. Plus, one of the most important reasons, actually, in our legislation, in 82, in paragraph 2, even if you do not actually resort to any force, etc., then the criminal offense is still committed, but there has not been an increase in the sanction. Therefore, we can still do the amendment of increasing the sanction, so the migrant smuggling and human trafficking could be regulated in parallel with each other. But we have a proportionality system in the criminal offense and sanctioning. Then the judges are reluctant. So we actually need to reorganize this particular provision. I'm just saying this is my personal view. In relation to conducting the investigation and the prosecution and the training to the judges and prosecutors, we actually need a training center, which, excuse me, a training approach that is the victim oriented, is centered around the victim. And this is one of the main issues that we need to regulate in relation to the investigation and prosecution of human trafficking criminal offenses. These criminal offenses need to be investigated and prosecuted with confidentiality. These are committed by organized crime groups, and these are actually important income lines for them. If you do not confiscate that income, you will not be able to successfully fight against these organizations. I have been in this profession for 30 years, and 26 years of this service has been in relation to organized crime groups. And again, in the content of organized crime groups, human trafficking and migrant trafficking is included. That's why we have been paying attention to this type of criminal offenses as well. I also do not believe that this is a national criminal offense. And I do not believe that the domestic legislation would be sufficient. Therefore, coordination amongst the national and international institutions is crucial. For instance, establishing IT systems, transferring information in a reciprocal manner would lead to much more efficient and much more faster investigations. And this is something that we need to resort to. I think that we need to regulate this particular area. Again, in relation to human trafficking, we have the victims' rights of human trafficking. I believe that there are special rights that are given to victims when they are subject to human trafficking. This is an exemplary establishment in the Turkish legislation. One is a residence permit. Second is not to deport the victims of human trafficking. Again, this is in the circular as well as in the legislation. And likewise, when we look at the victims of human trafficking, they do not need to pay any fee or anything, and they can immediately obtain a work permit. This is regulated in the International Labor Force Law, Article 16F. Therefore, victims of human trafficking are protected at the highest level, in addition to the other rights which my colleagues are going to explain to you. These are rights that are specific to victims of human trafficking. So please do warn me when my time is over. Okay, 4 more minutes. So I'm not going into the detail of the topic, to be honest. The criminal offense of human trafficking, we take this together with human trafficking as well as migrant trafficking. This is the criminal offense that ranks third in terms of the income derived after arms trade, narcotics trade, and human trafficking is in the third place. So this is an important item of income derivation. For these reasons, to strengthen the operational mechanism of combating human trafficking is crucial. I believe that there has to be a cooperation between the Ministry of Justice, the Ministry of Interior conducting joint operations, and there has to be international effective investigation. Likewise, when we're talking about human trafficking linked to prostitution, we need to conduct investigation against those individuals who have committed this crime, and there has to be cross-border legal regulations without paying attention to where this criminal offense has been submitted. If the criminal offense has been implemented more than once, we need to actually cooperate as to what kind of methodology we need to follow. Likewise, in human trafficking, there has been a misinformation in the Greta report. In the Turkish legislation, victims because they return back to their country, we have difficulty in taking their statements. Therefore, when we look at the courts, sometimes they say that we could not take this statement of the victim, and there are acquittal judgments. Of course, I have been responsible for this for very long years in Antalya. There is Article 162 of the Criminal Procedure Code, and it indicates that taking into consideration the fact that the victims of human trafficking might be going back to this country, we had a special practice in Antalya. According to this article, we were referring the victims to the judges, and the judges were taking their statements, and this was included in the case file. And the statements that we had taken at that instance were then used in prosecution. Because they have been statements taken before a judge, we did not need to repeat the statement. So this was actually what we used as a method in large-scale operations, and that's why the investigations led to a result. And I remember that in relation to the investigations that we carried out, there were cases that people were sanctioned for 130 years, from 30 years to 130 years. So in short, you need to conduct the investigation very carefully. When you put things together, it should be like the pieces of a puzzle. And when you have that puzzle before you, actually there is nowhere that the people can run away to. You need to collect the evidence. You need to actually fill the contents of the case file. And in that case, you will reach the result. Again, another important issue pertaining to human trafficking that we need to pay attention to is that victims and the offenders should not be kept in the same environment. The victim and the offender, if you put them in the same minibus taking to the doctor for physical examination, is there any possibility that they're not going to be affected? You bring them to court. On one side there is the victim, and next to them you keep the offender. So if that offender just shows a finger to the victim, is it possible for that victim to tell anything to you as a public prosecutor? It's not possible at all. Again, in relation to human trafficking, the material that we resorted to is sufficient in our legislation. We can actually resort to all methods, tapping, interception of telecommunications signals, technical surveillance. Again, since these are committed by organized crime groups, we can actually appoint whistleblowers or people who are confidentially involved in this group. And if you do this, and if you use all this methodology, this is not going to be a criminal offense that will be left unpunished. So for the last 20 years, as an individual and as a Turkish citizen who has been fighting against criminal groups, in the recent years, especially the DGMM and the Coast Guard, in relation to training and the operations that they conduct, have been very successful. And I would like to especially thank both groups. Thus, the other groups and other institutions should really follow their example in relation to adaptation, and they need to actually have a much more higher level of training that is going to be victim oriented. And I would like to thank you for paying attention to my remarks. Thank you. We would like to thank Mr. Yusuf Hakkıdoğan for these remarks. And now I would like to leave the floor to the head of department from Ministry of Justice, Madam Meral Gökkaya. You have 15 minutes.
Herkese merhabalar.
Thank you very much, and hello everyone. I will be talking from the perspective of the victims of human trafficking and not from the perspective of investigations. We are directly working with victims of the crime, and we provide legal support. And this department was established upon the approval of the minister. It's the Department for Legal Support and Victims' Rights. Back then, it was just the Department of Victims' Rights. And victims' rights have become a real need. And because of this need, several institutions started to establish specific units. And as the Ministry of Justice, we have established a separate unit as a Department of Legal Support and Victims' Rights in 2020. When it was established for the first time in 2013, it was just called Department of Victims' Rights. As Mr. Doğan said, taking the statements of victims and as for legal procedures, and as for providing legal support during the prosecution, we provide support to victims in collaboration with the Turkish Union of Bar Associations. At the center, at the headquarters, we have the department. Under the department, we have sections. And in other cities in the country, we have legal support units and directorates. We have directorates and also legal interview rooms. In the criminal procedure law, Article 236, we have an amendment. When there's qualified sexual abuse or exploitation, these legal interview rooms were to be used, and legal interview rooms were in use for some time in pilot courthouses, and we were happy with the results. We've seen that the legal interview rooms were meeting the needs of the victims, and with the presidential decree numbered 63, we have recruited staff for these units, and at the moment we have in 78 provinces and in 100 courthouses, we have 105 legal interview rooms, and we are still recruiting staff, and we have 400 people that are subject to scrutiny at the moment, and in September they will be appointed to sections and directorates. We have directorates, 155 directorates in 72 provinces. This means that we will be able to provide more support to the victims during the legal process. We also have civil and criminal prosecution support units. We also have legal support and legal support for vulnerable group units. And I would like to talk about how we use the legal interview rooms. When I started working for the first time, it was an assize court, and the human trafficking crime was considered under sexual crimes. And it was mainly forced labor of small children because of the situation in Syria, or prostitution. When it comes to prostitution, as Mr. Doğan said, it seems everyone is happy, but this is not the case all the time. At the SI's court I was working, I have seen women who came here from other countries to work as babysitters or cleaning ladies, and then their passports were confiscated and they were forced to prostitution. They were threatened, pressured, and they were forced to work for many years. So the investigation is carried out. It's organized crime, but then sometimes victims go back to their countries and it's difficult to investigate the crime. And when there were no legal interview rooms, the accused and the victim were in the same room with their lawyers present. And the victims sometimes were not aware of the fact that they had a lawyer. So this was just a formal procedure. It seemed that legal support was given, but the victim was not aware that the person standing next to her was her lawyer. And the victim, when giving a statement to the prosecutor or at the police station, they talk about their situation. However, when they're in the same room with the accused, they refrained from speaking the truth. So legal interview rooms step in at this point, and the victims are able to give a statement before they appear before the court. They're not in the presence of the accused, and we also have psychologists, pedagogists, and social workers working with the victims. And the 400 people that I have mentioned will be appointed as legal support officials. They consist of psychologists, pedagogists, and social workers. And the victims of human trafficking are also victims of sexual crimes. Legal interview rooms are not conducive places for sexual crime victims, actually. But taking the statement in the legal interview rooms showed the following. During the prosecution, I've seen this. For instance, a child who was sexually abused. This is not directly related to human trafficking, but I would like to give an example from the cases we see. Sometimes children of 9, 10, or 5 years old. The accused is in the hearing room as well. And back then, we asked the Ministry of Family to speak to the victims and to prepare them for the hearings. We did not have a specific room for that. I was giving my room to the Ministry of Health official and the victim, and the Ministry of Health official were preparing the victim for the hearing. But think of the judges on the bench, 3 judges on the bench, the prosecutor, the accused, lawyers. Think of the hearing room, and small children, young victims cannot speak. However, the judge has to ask them questions, or the lawyer of the accused asks questions, tries to cross-examine the child, and then the child stutters, hesitates. She has given a statement at the police station, maybe to the prosecutor, and giving another statement before the court, and she relives the trauma again and again, and she has to give the statement again and again, and this means secondary trauma. And sometimes they change their statement because they're scared of the accused. When the accused is in remand, the family of the accused sometimes threatens the child. Sometimes it's blackmail, it's extortion, or they offer money to the victims to change their statement. So in order to prevent secondary trauma and in order to find the truth, legal interview rooms are very important. We believe that they should be more widespread, and judges, prosecutors, law enforcement should have awareness as to using the legal interview rooms. There are training programs for this, for the judges, prosecutors, pre-service training programs at the Justice Academy. So judges and prosecutors some of the judges and prosecutors learned how to use these rooms because they were senior judges and prosecutors, but it's best to give the training to novice or young judges and prosecutors because the use of legal interview rooms is compulsory in the case of certain crimes, but we want to use these rooms for other crimes as well, so that victims are protected from trauma. In paragraph 4 of Article 234, there is a discretion granted to the judge in cases where the judge believes that the victim should not face the accused. The judge can decide that the statement of such victims can be taken in legal interview rooms. There was one case a few months ago. A child witnessed the killing of her mother, and she appears before the court. She's 5 or 6 years old, and the judge asks, "Will you be able to give the statement here?" And she says, "The man who killed my mother is here. I don't want to talk here." And then they asked for a legal interview room. However, what we want is to take the statement of such victims directly at the legal interview rooms. The same applies to human trafficking victims as well. They're forced to prostitution, they're deprived of their liberty, their passports are confiscated, they don't know where to go. Some does not speak the language. We also have a mail address to provide information to victims of human trafficking and sexual crimes. The information about the mail address, information about where they should apply if they are a victim of a crime, have all been translated into several languages. The authorities that they can go to. We also have some brochures on our website. The website is in English, Turkish, and Arabic. Brochures are in English, Arabic, Turkish, and Persian. We also have a guideline describing how the practitioners should approach the victims. The guideline has been updated recently. Judges, prosecutors, police, healthcare professionals, those people who see the victim can use this guideline to learn how they should approach the victim. The guideline physically has been distributed to courthouses and relevant institutions, and it's possible to have access to these brochures or the guideline online. We also have a twinning project which created a guideline for victims' rights. We also have some training programs among ourselves, and during the pandemic we had to organize online training programs. Some were organized physically, and we provide information to our staff as to how they should proceed with legal procedures concerning victims. We also have certain projects that are in progress. The DGMM has certain projects. We also contribute to those projects to support DGMM and also to train our own staff members. So we collaborate with other authorities and institutions as well. The most important thing here is to raise awareness, as Mr. Doğan said, to raise awareness both among the victims and practitioners. If we can raise awareness, then everyone will understand that the victim is a human being. And what she has been through is something that affected and shook the core of her life. I mean, it's not just taking the statement of a victim for an hour or two. We shouldn't see it like that as judges and prosecutors. We always consider the legal aspect of the case, of course. We try to see whether there's a crime. We take the statement. However, the victim is reliving the trauma again while talking to us. Therefore, we need to provide psychosocial support to these victims at the Legal Support and Victims' Rights Directorates. We have psychologists for victims, especially victims from vulnerable groups. So we provide a legal support program, and we are there for the victim, and we also provide such support to victims. This is how we work, and let me give you some figures. For example, in criminal cases, the number of statements that were accompanied is more than 37,000 since the department was established. It's 4,986 in civil cases, and we have taken care of more than 144,000 people at the legal support units. And when we look at the practice, we see that legal interview rooms are mainly used for sexual crimes, but we believe that those rooms should be used for children who are drawn to crime or for other victims of crimes as well. Thank you very much. Thank you very much. Now I would like to give the floor to Mr. Rıfat Sagut, public prosecutor from the Court of Cassation. Good morning, ladies and gentlemen. My name is Rıfat Sagut. I'm a public prosecutor at the Court of Cassation, and I'm the public prosecutor at the Court of Cassation for 9 years. And before that, I have worked as a judge at the 8th chamber at the Court of Cassation that deals with human trafficking crimes. And before that, I was a prosecutor for 9 years. So I started working at the Court of Cassation in 2000, and it's been more than 20 years. And in 2001, some amendments have been introduced into the law for human trafficking, and the president of the Court of Cassation invited me to his room, and he said, migrant and human trafficking crimes have been introduced into our law, he said. Now you're going to deal with these crimes. And I said, I'm working on terrorism. I don't want to. And he said, I'm not asking you. And there was another colleague with me called Mehmet. And he said, one of you should work on this. And since 2002, I've been working on human and migrant trafficking at the Court of Cassation. In the beginning, it was very difficult because the legislation was quite new. We didn't have enough resources. ICPMD had some training materials. I had them translated, and I was giving presentations and lectures. And then I met IOM in 2008. And IOM had the project, and in the project, in collaboration with IOM, we have published a book in 2016. We have published it again. This is the book that I'm talking about. I can easily say that it's the best book on human trafficking in the market. And I was involved in the training of judges, prosecutors, gendarmerie, police, Ministry of Family, Ministry of Labor staff, and also I have provided training to them, and I've been working as a trainer at the Justice Academy for the last 3 years, and I'm training judges and prosecutors on human trafficking. So the human trafficking is stipulated in the Turkish Criminal Code, and the third article of the Palermo Protocol has been translated, not identically, of course. However, Article 3 of the Palermo Protocol and Article 4 of the Council of Europe Convention are the same. However, there have been some misunderstandings and mistranslations of these articles while the crime was introduced into the Turkish Criminal Code. So we need to amend the law now.
tercümesi oldu.
Well, since this is a translation of an international convention, it's not very easy to understand. It's very complex. In order to understand it better, we divide the article to three: the instrumental acts, main acts, and the purpose of the perpetrator. So, what are the first acts? These are the acts that include deceit, or threat, pressure, force, or violence, abusing his influence, or obtaining a consent by exploiting control over another or the desperation of such other. So when we look at these acts, they are very similar to each other. Why would we need to have such an arrangement? Because we want to criminalize the perpetrator. This is the principle of law. So all acts need to be defined. Actually, the exploiting control over people, this definition in Palermo Protocol, it says people, a person having control over another person for the purpose of exploitation. So giving or receiving payments or benefits to achieve the consent of a person having control over another person. So this is not a direct translation. So this is desperation. Desperation is, the term desperation is not understood very well. It's actually a subjective desperation. What is subjective desperation? It means we have to assess everyone based on their situation. People who doesn't know the language of the country they went to, they don't have money, so that person's desperation might not be the same with our or others' desperations. And there are main acts, and these acts are to kidnap these people, or practices such as putting people inside the country or take them outside of the country. In the first part, it was not included, but in 2006, December of 2006, it was added to this article. Again, there are some discrepancies with the Council, with the Convention of the Council of Europe, but we might need to talk about it for 2 days, but we have limited time. That is why we will go on more superficially. Victims can be everyone. If for children, we are not thinking about instrumental acts. So what would happen? Well, we have Article 61 of Turkish Penal Code. In Article 61, if there is such an act, the judge needs to give the sentence which is distant from the base sanction. So there should be some purposes, of course, for this crime, which are prostitution, or provide a service, or harvest their organs. So these are the purposes. Well, for the crime to take place, these purposes are not required. Human trafficking is a criminal offense. So purpose of forcing them into prostitution or to work, provide a service, harvest their organs, or using the act instrumental to the offense, or taking them somewhere else. If there is an act instrumental, then we don't need to have the purpose. But if the purpose is realized and these purposes also create a criminal offense, then additional sanctions are provided. Both human trafficking plus prostitution, both human trafficking crime plus forced labor plus harvesting their organs. So all these acts are punished separately. Sometimes in practice, in Greta's report they also mention it. They say the criminal offense of human trafficking are confused with other offenses in practice, but actually they're not. There's nothing to confuse. Well, in human trafficking, you can confuse it with prostitution. Well, it cannot be confused with it. It might be lack of knowledge. What do we say for the crime of human trafficking? It's a primary crime. It has to have some purpose, but it doesn't need to be completed. So the sentence is from 8 years to 12 years. But prostitution has a sentence of 3 years. So if you deceive someone from abroad, you harbor them, you take them in, you take them into a country, confiscate their passport, put them into a house, and you force them to prostitution. There's prostitution, and the crime is the sentence is 3 years. So the sentence of the act is 8 years, and the results sentence is 3 years. So, or let's say for harvesting their organs, you take someone from outside the country, you take them into a hospital, the person is on the operation desk, but you didn't harvest the organs. If you don't harvest the organs, the act requires 8 years of sentence. But if you take the organs, if you harvest the organs, the action requires a sentence of 3 years. It's not the case. What? In Turkish Penal Code, there is Article 43. Well, with one act, if more than one provision of the law is violated, then the most aggravated sentence is given. Since the human trafficking sentence is higher, that needs to be executed. So there cannot be a confusion in this regard. Well, human trafficking is a crime that is prosecuted ex officio. We don't look for consent since it is more than 10 years. Mostly it is under the heavy criminal courts, and there's also a jurisdiction issue in terms of human trafficking. Well, Article 13 of Turkish Penal Code talks about universality. Wherever the crime is perpetrated, whatever the perpetrator's nationality is, even though there's an acquittal in another country, the same act can be prosecuted under the Turkish law. So the sanction of this crime varies from 8 years to 12 years. It's imprisonment. Also, as well as imprisonment, a high amount of day legal fine is executed. More than 10,000 days of legal fine is imposed. You are hearing it since yesterday. It is a very profitable crime. In the law, it says in crimes with the purpose of obtaining a profit, the profit shall not be forfeited to the accused. That is the principle. Well, the rule is actually to confiscate the proceeds of crime. We do know that this person has committed this crime. We know that they made a lot of money, but when we investigate, we cannot determine their assets. What are we going to do? Shall we forget about it? No. We give 10,000. We can, if the judge wants, they can impose 10,000 days. It's around 20 lira to 100 lira per day. So 10,000 days, 100 lira per day, it's a large amount of monetary fine. Therefore, well, human trafficking crime, we say it is regulated in Article 80, and it is identical translation of Palermo Protocol Article 3. It's not that different from other European countries' legislation, apart from some translation mistakes. But the difference is that our sentences are very high. I will also talk about the European Council Convention. As you know, the Council of Europe Convention was signed in 2009 and it was adopted by the Parliament in 2016. And international conventions adopted by the Parliament, as you know, Article 90 of the Constitution, becomes domestic law. It is it prevails over domestic laws even, because laws cannot be against the Constitution. Maybe the laws can be reviewed in terms of discrepancies with Constitution, but the laws cannot have any discrepancies with international conventions. Actually, this convention is very appropriate, and I do believe that in our law, we need an amendment. We need that it is the case for all crimes, all criminal offenses. Yusuf Hakkı already mentioned it. For example, migrant smuggling is a simpler crime than human trafficking. Why? It has less violation of human rights. That is why, although in that article the qualified cases have been regulated, under human trafficking, the qualified cases are not regulated. It is written in the convention, actually. And well, since 2002, I have been working in the area of human trafficking. Well, actually, after the year 2009, the Council of Europe's convention was reviewed by a commission. IOM led that commission, actually, and we have worked on this amendment of the law. But then there was a confusion and everything stayed on the shelf. But what have we written in this amendment of the law? Well, first, we said this force and coercion for human trafficking. If the Council Convention also mentioned if it is qualified, if there is injury, then you also sanction the person for additional crimes. We said coercion and violence. Well, slapping a person is also violence, but the results are not the same if you stab a person. So if there is a qualified case, then additional sanctions are imposed. This is correct. We have written it in the amendment. Well, actually in TV, in a comedy show, there's this guy, and I look like him right now. He always says, we explained this, we talked through this already, and we had written it, indeed. Well, if that person knowingly abuses vulnerability of a person, that requires additional sanctions as well. And if the crime is perpetrated against a child, or if it is perpetrated by a public official in their duty, additional sanctions. But it might be also considered that if this crime is perpetrated based on a group activity, organized activity, then it should be more aggravated. I do believe in it, and actually, in line with Article 90 of the Constitution, these amendments must be made. Well, in a hotel in Ankara, 8-9 years ago, there were professors discussing that there should be an amendment in this law, and I was explaining that we should do this, and we had worked on this issue back then, and people were looking on their phones, and they said, well, you actually worked on this issue. If we amend this law, how many people would benefit? Well, I claimed that the bottom limit should not be 8 years but 5 years, and we should increase the ceiling. But then they said they need to work for longer periods on this. But it is not what I want. Since we have signed the Council of Europe Convention, and since this convention requires this, we must make these amendments. Well, there are a lot of things to explain. Actually, I did listen to Greta's report. I actually memorized Greta's report already. And Greta says, well, I will refer to Greta's report. We have written this booklet in 2016, and Greta's report is dated 2019 because they visited the country in 2018. Well, what we said here is that the crime of human trafficking creates problems, and in order to resolve the regulatory problems, and in order to meet the requirements of international conventions, the first paragraph of Article 80 of Turkish Penal Code should include prostitution, forced labor, enslavement, servitude, begging, forced begging, harvesting of organs, recording of private images. So these should be added. We said it way back in 2016. Well, actually, I'm very surprised by Greta. Well, they're the experts group, but we had already realized this before them, and we said this should be added. Again, in page 125 of the booklet, we say that in the first paragraph, these acts, if people who knowingly abuse the vulnerabilities of people should have additional sanctions. Well, in our law, there's Article 266. What's 266? It says if public officials perpetrate a crime, then the sanctions should be higher. Well, they say this article already regulates this. That is why they say it's not necessary. But can we add it? Why not? Why? Well, it's great to listen from you. That's why I allowed more time for you. But your time is over. Maybe we can hear you more during the coffee break. Thank you very much, Mr. Rifat. I would like to thank all three esteemed speakers for their speeches, and thank you very much for your patience. Since we have a time limit, we are not going to receive any questions for this session. So if you allow me, I will adjourn this session now. Thank you very much. Yes, distinguished guests, in the third session of our summit, we discussed the legal basis of human trafficking crime. I would like to thank our moderator, Mr. Değirmenci, and our panelists, Mr. Doğan, Mr. Gökaya, and Miss Gökaya, and Mr. Sagut. Thank you all very much. This was very comprehensive, and you provided detailed information for us. We will continue with the fourth session, but it is now the time to take a breather. Let us give a coffee break of 20 minutes, and then we will initiate the fourth session.
Regarde-moi, j'ai besoin que tu viennes.
Çağlar Bey'in.
Değerli katılımcılar,
Distinguished guests, esteemed participants, now we will start the fourth session of our summit. The session is on Article 80 of the Turkish Penal Code in the framework of the National Action Plan on Human Rights. To moderate this session, I would like to invite on stage the Deputy Head of Human Rights Department, the Ministry of Justice, Mr. Ahmet Müşerref Yakışık. And our panelists, from Ministry of Justice, Deputy Director General of Criminal Affairs, Mr. Şenol Taş. From the Ministry of Justice, Deputy Director General of Legislation, Mr. Abuzer Yazıcıoğlu. From Gendarmerie General Command, Head of Department of Counter Smuggling and Trafficking, Mr. Bülent Balkay, Senior Colonel. From the Director General of Migration Management, Head of Department of Protection of Victims of Trafficking in Human Beings, Mr. Osman Koramaz. From TOBB University, Vice Dean, Professor Dr. Mr. Olgun Değirmenci. Once again, we would like to invite you on the stage. Mr. Yakışık, I would like to leave you the floor for the moderation of the panel. Thank you very much. First of all, I would like to welcome all participants, and I would like to welcome our panelists. We have 1 hour. That is why we will try to use the time optimally. The National Action Plan on Human Rights, as you know, was adopted on the 2nd of March 2021. It was announced to the public by our president, and as of the 30th of April, the implementation calendar was published. In the implementation time frame, what is meant is the activities envisaged in the action plan, their durations, the responsible organizations and institutions are stipulated in this implementation calendar, and in this scope, the targets in the action plan are envisaged to be completed within 2 years. That is why, simultaneously with this implementation calendar, there was a circular published by our president, and in this circular it is stated that the responsible institutions would carry out the activities foreseen in the action plan with utmost care. One issue is very important. In the circular, a monitoring and evaluation board is envisaged, which will be chaired by the vice president, by the president himself, and then including the vice president and 6 ministers would also be members of this monitoring and evaluation board, and the secretariat is to be carried out by our ministry, the Ministry of Justice. So since the action plan is published, its publication is not the important detail. The important issue is its implementation, and all necessary measures have been taken, and reporting in 4-month periods are envisaged, and then these reports are going to be sent to the MNE board. They will be reported, and in terms of implementation of the action plan, the public will be informed. Regarding our summit, our main topic is mostly about migrant smuggling and human trafficking. So in this sense, in the National Action Plan, this issue is especially underlined for the vulnerable groups. Under the goal topic, it is specified as a separate target. And in this specific target, in the scope of anti-trafficking in the action plan, some activities were directly envisaged. And not only the activities under this target, but also the direct human trafficking related to migrants and vulnerable groups. Many activities are included in the action plan. Well, I do not want to prolong my words, of course. First of all, we will hear from the Deputy Director of Criminal Affairs, Mr. Şenol. I would like to give you the floor. You have so since we have a total of 5 panelists, we would like to use the time optimally. And if we have time left, I will try to receive some questions and provide some answers. But it depends totally on how much time we can save in the panel. If you can finish your intervention in 8 minutes, it will be ideal. You have the floor, sir.
Distinguished moderator, thank you very much. And I would like to greet all of the participants. As you know, in relation to the summit on combating human trafficking, our topic is the efforts to be undertaken in line with the Human Rights Action Plan. But I would like to start from the point that human beings are a sacred being. And there's a saying of Rumi says that humanity is about thinking and thoughts. The remaining part is just bones and muscle. Of course, the evolution of the humanity is important. When we say human trafficking, we're talking of it as if it is our item to batter. And as you know, with respect to the geographical position of our country, we are in an intense area, and these topics are quite frequently raised these days, the issue of migrant smuggling. This is, of course, not just a national matter, but it's also an international issue that needs to be evaluated as such. In the previous session, we listened to panelists talking about what does the legislation say pertaining to human trafficking. And I would like to briefly talk about these. In our legislation, human trafficking is regulated in Article 80 of the Turkish Penal Code. Here, there are different definitions about the aim of the criminal offense. And as you know, the sanction is from 8 to 12 years. And the assize courts have jurisdiction. There is also monetary fines that are foreseen for such criminal offenses. We need to approach the matter from the following angle. In the Human Rights Action Plan, the Ministry of Justice is given the task of undertaking Action 8, and item B of this item is to provide relevant training for public prosecutors and judges pertaining to human trafficking. And there is also an item that refers that the sanctions are to be reviewed. Of course, the Department of Legal Affairs are also here present, and they will be talking whether the sanctions are sufficient or not. In the previous session, the distinguished public prosecutor has indicated that there could be certain changes and amendments made to the level of the sanction. Once you do this, of course, you need to elaborate whether this is a pro or con, and this is going to be extending the duration of prosecution, and it will have side effects of limiting the access to justice. In relation to training, I have contacted the Justice Academy, and they're also one of the stakeholders, the beneficiaries of this project. Our training activities for judges and prosecutors are continuing, and in the previous session, Our distinguished prosecutor who took part in such trainings voiced his opinion and perspective. In 2020, 455 public prosecutors have received pre-service training on human trafficking. In 2021, 312 candidate prosecutors also received pre-service training on human trafficking. These are training activities that are both theoretical as well as practical, benefiting from contemporary information. The Human Rights Action Plan also indicates that this is going to be a continuous activity. Such training activities have already been realized in 2021 and will continue to be organized. Of course, it's not just sufficient to provide training. We need to continue to monitor the situation. I also talked with the head of Department of Judicial Statistics, and I would like to share the last data with you on data from 2019. The number of cases that are pending is 201, and there have been 58 new cases within the year, and 87 have been cases that have been ruled. There were 176 pending cases at the end of the year. One important aspect is the limited number of offenders who have been sanctioned. I don't want to inform you with a lot of figures, but there are a lot of offenders or suspects who have been acquitted. When we evaluate such judgments together with our colleagues here, we see that the judges who are responsible for such cases are mostly sanctioning the offenders for prostitution, because the human trafficking has a higher sentence, and since the connections have not been very clearly set forward with respect to the evidence, so mostly also victims you can see is consisting of women and children. They are either the people who are used for prostitution. So instead of the very high sentence, the judges prefer to issue a sentence on prostitution. And in order to avoid this, we need to have a much more effective investigation, establishing the connections of human trafficking, and thus including such evidence in the case. Sometimes the public prosecutor does not pay sufficient information to this evidence. In the end, an effective investigation to be followed by an effective prosecution will become even more healthy. This is our aim and target. And in relation to such aims and targets, this is a top task that has been given to the ministry, and we need to survey the situation. Following it with the training, we have cooperation with the Justice Academy on this, increasing sanction, bringing the qualification perspective. Our colleagues are going to mention. I don't want to interfere in the time limit of my colleagues that much, and I would like to end my remarks here. And thank you very much for your patience, ladies and gentlemen. We would like to thank Mr. Tash for his comments. Of course, in relation to human trafficking, he mostly talked about Article 80 of the Turkish Penal Code. And in relation to the amendments, he referred to the fact that the Director General from the Legal Affairs Department could make an explanation on this issue. And in relation to the implementation, he indicated that they are working with the Justice Academy to fulfill the requirements of the Human Rights Action Plan, thus providing regular training to the candidate public prosecutors. He also mentioned that this is a continuous training. Also, in relation to human trafficking, he mentioned the difficulty in collecting evidence for this criminal offense. Thus, when the case file appears before the judges, when you look at the evidence within the case file, they need to pass judgment in relation to that evidence, and most of the time in such case files, there might be an impunity because of lack of sufficient evidence, and we would like to thank him for his valuable comments. Now I would like to leave the floor to Mr. Bülent Baykal. He is the head of the department from the Department of Counter-Smuggling and Trafficking from the Gendarmerie General Command. Thank you very much, distinguished participants. Of course, we have academicians who will be talking about the scientific and academic matter of the issue. So without interfering into that area, I will be talking about the Human Rights Action Plan tasks falling on the Gendarmerie. As a Gendarmerie General Command, first of all, we have identified the possible target group, and what we have identified is, in relation to human trafficking, the people who might be subject to such human trafficking is actually foreigners, women and children. And when we analyze the contact of this group with the Gendarmerie, we come across to the following picture: the irregular migrants that have been apprehended in our country by the law enforcement. 60% of these have been apprehended by the Gendarmerie in the past, and today this figure has increased to 80%. So the initial contact is with the Gendarmerie. And of course, we have the administrative detention, we have the removal centers, and although this is the task of the chairperson here, we have more than 120 removal centers, and these are special locations for the external security, which also pays attention to the healthcare needs and the deportation of such individuals. All of the transfers and the management of such people is governed by the Gendarmerie. So if we are to give a figure, in 1 year there is more than 100,000 people who are under administrative detention. And as you know, we are responsible for many of the transfers, and that's all this 100,000 persons come across to the Gendarmerie at one point. After identifying this, in line with the Human Rights Action Plan, as mentioned in the plans of our organization, we paid special attention to the training. The Gendarmerie staff is trained by the training institutions of the Gendarmerie and recruited. So a Gendarmerie officer has 1 year induction courses followed by 4-year academy, and we train Gendarmerie officers in the Gendarmerie and Coast Guard Academy for 2 years or 4 years, and the expert Gendarmerie staff are trained in the training academy of the Gendarmerie and the Coast Guard. In 2020, there were 4,500 members of staff who were trained in the academy under human rights and human trafficking, smuggling of migrants, and investigations for human trafficking and migrant smuggling. Such training has been rendered. So it's not just the newly graduating personnel that is to be educated. As the first speaker has mentioned, we had a coup attempt in 2016, and also in our staff there was a big change. So we also conduct in-service training in the format of distant learning as well as TOTs. So in 2020, we have provided training to 8,700 personnel. Of course, the action plan is not just important for the newly recruited personnel and for investigative personnel, but it also has an expectation of training the high-level staff. And in 2020, the provincial gendarmerie commanders, the district commanders, and personnel that is at the management position, 400 of them have received face-to-face training. As you know, the EU project under which we organize this summit is conducted under the coordination of the Council of Europe. And there is the help platform of the Council of Europe. This is the Human Rights Education to Legal Professionals. This is a really good training platform. And I believe many of the participants here have had a connection with that platform. This platform provides training to legal professionals like judges, prosecutors, but also staff of the public notaries, gendarmerie, and open to many different groups of professionals. And from this platform, 50 trainers have received training. And the expectation we have is that 50 trainers shall be providing training to 5,000 staff. This training was not for a limited period, it was almost for 2 months, and it has been very productive. In this context, I would like to actually thank the relevant members of staff who have participated in the assistance of this platform. I do not want to take too much of your time, and I would like to end my remarks here. Of course, there are a lot of things that we could say on this point, but thank you very much for giving me this opportunity. Thank you very much, Mr. Moderator. In relation to the Human Rights Action Plan, we have listened to the views of the gendarmerie and the matters that fall under their jurisdiction. Of course, he mentioned issues such as gendarmerie being the first in contact with such individuals, and also underlined the importance of the training of such individuals because they're the first point of contact, and underlined their training activities to achieve this aim. So there is training when they are recruited as members of staff at the academy, and he also mentioned there is in-service training for people who have been recruited, and he mentioned that despite the pandemic, high-level staff have also received this training, and underlined that they benefited from the help courses on human trafficking and migrant smuggling, and that such activities shall be continued. Then I would like to thank him for his remarks. Now the third panelist shall be Mr. Osman Koramaz, who is from the Department of Protection of Victims from the Migration Management. Distinguished participants, distinguished panelists, and distinguished moderator, I would like to greet each and every one of you. I would like to indicate that if there is an amendment foreseen in the Turkish Penal Code, there are certain aspects that are crucial in my opinion. In the text of the legislation, there are provisions like forced labor, prostitution, and forced service. Here I see a loophole like forced marriage or organs and tissues trading, using children for criminal offenses and forcing them for begging. I do believe that this should be clearly delineated in the text of the provision. Plus, I believe that it is also confusing. I don't believe that bringing into the country or forcing them to leave the country is not necessary in the wording. There is the transfer, and I think that the transfer covers both items. Another aspect is for aggravating reasons when it's committed against a child or when it's committed by a public official. Such issues should be indicated clearly within the wording, and I believe that this is going to be beneficial during the prosecution as well as for clarifying the issue. These are the aspects that I wanted to raise, and I would like to thank you and to greet each and every one of you with respect.
Teşekkür ederim Sayın Başkanım.
Thank you very much. I actually warned all the panelists very strictly to limit their speech with the time we have. And everyone actually has been very careful in observing the limits. Maybe we will have more time for the questions at the end of the panelist. The head of the department talked about the relevant Article 82 of the Turkish Criminal Code, and he made certain suggestions, such as forced marriage, to be introduced into the article, and also tissue harvesting. He also said that there is a confusion between human trafficking and migrant smuggling, and he focused on Article 72 of the Turkish Criminal Code, and he said that aggravated circumstances must be introduced into Article 82. For instance, if the crime is committed against children, this should be an aggravated circumstance, he said. Thank you very much. I now would like to give the floor to Professor Olgun Değirmenci. He is the Vice Dean of TOBB University. The floor is yours. Thank you very much. Let me use the time that is left of other panelists, but I will, of course, leave time for Mr. Abuzer. When I was asked to deliver this presentation, I prepared an outline for the presentation, and the main focus was a human rights action plan, and I have read the action plan. The president announced the action plan in March 2021, and the action plan stipulates that the recommendations of Greta and the convention, the Council of Europe Convention, will be taken into account to investigate and sentence human trafficking. So I'm going to be building my presentation on this plan. So I'll talk about generally what human trafficking is, and I will make an assessment within the framework of Palermo Protocol and then within the framework of the Council of Europe Convention. So within the context of Palermo Protocol, I will say the following. Palermo Protocol brings along an obligation to countries. Even if Palermo Protocol is transposed to the national law, Palermo Protocol cannot create a norm of crime in the national legislation. So Palermo Protocol says that it should be intentional and you should sentence and penalize it. It should be of a transnational and transboundary nature, and if this crime is committed by an organized crime network, sentencing and penalizing is a must. So our regulation in Turkey actually meets these criteria. And Palermo Protocol also says that, but let me first talk about the crime norm. when we look at the objectives, and as Mr. Rafat said, this is such a complex crime, and criminal lawyers actually have a very hard time when dealing with such a complex crime. And it's very difficult to really understand this crime. And the international conventions always have a vague language because they have to cover multiple countries. And therefore, while transposing these international instruments into the national law, we sometimes use synonyms of different words. For instance, we say coercion and force, but we don't have to use it in that way. But when in terms of the objectives of the Palermo Protocol, we see that other forms of sexual abuse are not covered by this protocol. If we are to define sexual abuse, and in Article 103, there is a definition of sexual abuse of children, maybe we can then overcome this problem. And practices similar to servitude is not covered by the Palermo Protocol as well. But I'm just giving you some food for thought. Maybe we can relate this with relevant articles in the Turkish Criminal Code. Mr. Rafat also talked about making benefit or profit for a certain person or for others. While transposing this to the national law, we have the regulation and also abduction. Actually, in our regulation, we have a wider interpretation of this act, and our legislation does not cover surrender or handover. But Palermo Protocol also says to all state parties that all these acts need to be penalized, but also intent or attempt need to be penalized, and incentivizing crime should also be penalized, Palermo Protocol says. So what is the situation in our country, in our legislation? Article 5 of the protocol is titled based on the practices of state parties. So Palermo Protocol does not say that a crime of attempt need to be created. And in terms of collaboration for a crime, law number 3241 is enough for us. So incentivizing or encouragement for crime and the organized nature of the crime are all regulated in our legislation. We don't have any problem there. And I'm also talked about abduction and the relevant article. Now let me talk about the Council of Europe Convention on Action Against Human Trafficking, Trafficking in Human Beings. Do we have any shortcomings in the national legislation? Article 4 says that perpetrators need to be sentenced and penalized when there's intent. And Council of Europe Convention actually brings along another condition, and the sentencing need to be appropriate for the extradition of criminals. And the convention says that the limit for the punishment should be 1 year. In our legislation, this is much higher. And We actually have done a study on the Council of Europe Convention, and we have a very comprehensive report, 150 pages. It will be published in English as well. And we have asked about the implementation of Article 19 of the Convention to practitioners. And there are two views. One says that it should not, benefiting from the services of the victim need not be punished. But if there's no consent, any sexual intercourse with a person without consent, then there is a certain sentence. However, in Article 83, it says that even if there's consent, there's a crime. There can be consent in terms of service provided, but it might not be corresponding to other types of crime. So there is a confusion in the national legislation between Articles 80 and 83 of the Turkish Criminal Code. So we need to work on this and think about this. Any fake travel documents or publication of identities, this is punished in the Turkish national legislation as well. However, if this document is a product or a goods, then this might also be considered as theft. We have regulations that meet the criteria in the Council of Europe Convention in terms of qualified circumstances. And the convention says that the punishment can be given either in the administrative or the civil law area. And we see that sanctions are imposed on legal entities as well, according to our legislation. And as Mr. Osman and Mr. Rıfat mentioned in their interventions, when the life of the victim is jeopardized because of threat or otherwise, this might fall under the scope of Article 87 of the Turkish Criminal Code. And in Article 79, we're talking about this. The limit is 1 year. However, the punishment has a higher margin in our country, so we can always use the upper limit, we can say. But then why do we write this in Article 79? Committing the crime against a child can be aggravating or qualified circumstances. Article 266 is not enough for this. 266 mentions the use of public instruments. However, the crime can be committed without the use of public instruments. Then you cannot use Article 266. We have to think about this. When the crime is committed within the framework of the organized crime network activities, 224, Article 224 actually talks about this. However, Article 79 contradicts with this, so there is a conflict here, and not punishing the victim. So in the national legislation, we base our acts on Article 128. However, when there is consent and when there is no coercion or force, the punishment of the victim might be possible. So we need to rectify this. The German law stipulates the following. Even if the victim has committed a crime, the prosecutor may not prosecute the victim. When you consider Article 128 within the framework of Article 171. The prosecutor might prosecute the victim, but no punishment is necessary. So we need to rectify these contradictions. So the Articles 80, paragraphs 1 and 3 of Article 8 of the Turkish Criminal Code is not in line with the protocol or the Council of Europe Convention. We need to rectify this. And we also need to consider handing over and taking over concepts, and other types and forms of sexual abuse should be among the objectives. Forced labor or forcing children or victims of trafficking in human beings to beg can also be given as a consideration. But however, I should also say that when you write everything in the Turkish Criminal Code, the situation becomes more complex. But when you do not write it, then people might think that the lawmaker would have written it if that was the intention. Tissue harvesting or organ harvesting, these need to be carefully considered. So the organ also entails tissue, but tissue does not entail organ alone. So we need to be careful about that as well. And finally, we are on the scientific committee together with Mr. Abuzar, and we're very careful about the reduction of the sentence, because even if you reduce the sentence by 1 year, then you have to go back and reconsider all the cases. This is not the case in the German criminal law. However, we do not know what this will result in or what it will trigger, so we have to be very careful. Thank you very much for your attention. Thank you, Mr. Olgun Değirmenci. Thank you very much for this very useful information. He talked about the Palermo Protocol and Council of Europe Convention, and he made an assessment of Article 8 of the Turkish Criminal Code within the framework of these two instruments. And he said that the provisions in Article 8 of the Turkish Criminal Code meet the criteria in these two instruments in general. However, he also said that there is need for certain amendments in Article 80, for instance, especially in terms of aggravating circumstances, and in terms of not punishing the victim. He said that the general provision in the Turkish Criminal Code falls short, so a specific provision is needed for that. Thank you very much. Now, the last speaker of our panel is Mr. Abuzar Yazıcıoğlu, Deputy Director of the General Directorate for Legislation. The floor is yours, sir. Distinguished guests, ladies and gentlemen, I would like to welcome each and every one of you. I don't know if this can be translated, but it's always very difficult for the last speaker to take the floor. I was really concerned that the previous panelists would talk about my points, but they also left me something to say. But I will, of course, have to dwell on similar points with the previous panelists while listening to the professor and recommendations by the president. I was thinking, I wish this article was being drafted for the first time so that we could include all these issues in the article from the very beginning, because when you introduce a new word in an article, a new meaning is attributed to it as well. and people start to interpret that the word is limiting or um, providing a much broader interpretation, and this is confusing for the lawmaker as well. The professor talked about the contradictions between paragraphs 1 and 3 of Article 80. When we look at the history of these paragraphs, we see that those statements were added with the law 5560 and maybe a little bit randomly. Maybe they felt the need to introduce these words, but then they forgot about Article 3. So you shouldn't rush and hurry while drafting legislation, and they should be more inclusive.
ifade ettikten sonra
After mentioning these, I will try to avoid repetition. I will try not to repeat the words of the previous panelists. I will touch upon a few issues and finish my speech. I want to actually emphasize one more thing. While I was preparing this presentation, I've used the article of Professor Orgun, which was published in the Journal of the Bar Association. I would like to mention that I made use of this article, and if you allow me, I will recite you. Well, distinguished guests, human trafficking crime is a new crime. It was put in the Turkish Penal Code in background 19 years ago. Actually, in August, I believe this crime is going to celebrate its 19th year. It was adopted in the parliament 19 years ago, and as Article 201/B, it is criminalized in the Turkish Penal Code. In the arrangement, legal arrangements back then, as mentioned by Professor, it was if the crime is perpetrated as an organized crime, it was mentioned as an aggravating cause, but in the new amendment, that paragraph was taken out. We need to review well why this aggravating factor was deleted. That is why I actually wanted to start from the historical developments. We should also know the previous issues. Since human trafficking is directly linked with human rights, human dignity, why are we seeing it as a new crime? Because slavery in history was considered legitimized internationally, and until the end of the 19th century, slavery was a legal act. Actually, UK lifted slavery or banned slavery in 1800s, and then the Ottoman Empire bans slavery, and then France, USA, and Spain, and then other European countries start banning, prohibiting slavery one by one. But legally arranging it as a criminal offense, it comes later. In the beginning of 1900s, the first text is the International Agreement on Lifting White Women Trade, and it was signed on in 1904. And previous panelists already mentioned, and Mr. Rifat already talked about some details of the Palermo Protocol. It is important for us because this Article 201/B of the law number 7065 directly refers to Palermo Protocol. This is added as a criminal offense in the Turkish Penal Code based on the Palermo Protocol. Well, 3 years later, when the new Turkish Penal Code was enacted, this new text comes forward, and in 2006, the acts of prostitution, bringing a person in the country or take a person out the country, are listed as acts. Well, since this is a young criminal offense, we need to study on it more. It needs more attention. It needs more contribution from the experts. And as the Director General of Legislation, we do believe that this crime should be studied more. Well, actually, the Action Plan on Human Rights and Greta recommendations shall be referred to in these activities. I will check my notes in order to avoid repetition. Of course, according to the socioeconomic position of our country, it is both a receiving country in terms of migration, and there is out migration from the country. In parallel with this, human trafficking can be towards our country or outside of our country. That is why this criminal offense is very important in terms of our country. The Director General provided some statistics. Maybe they're not very striking. Maybe the numbers seem low. Well, this is due to the difficulty of proving this crime, because in order for a criminal offense to be proven, you need. It is difficult to find a stronger evidence than the statement of the victim. At the moment, we have better tools such as tapping or video recordings or using some agents, but these are difficult tools, of course. And in order to identify the criminal offense, we do believe in the difficulties faced by the practitioners, and victims can refrain from giving their statements. And in the previous panel, one representative talked about legal interview rooms, and if they are implemented more effectively, we can overcome some of these challenges, and it is a pleasing development. When we talk about human rights action plan, well, the story of the action plan was already talked about by our previous speakers. I will not talk about it, but in the action plan, there are more training type of activities regarding practice. But we have one action regarding legislation. Well, criminal provisions and penalties related to human trafficking will be reviewed in accordance with the Council of Europe Convention on Action Against Trafficking in Human Beings and the recommendations of Greta. This is a very general expression, but Greta's 2019 recommendations have been reviewed by our ministry one by one. They're very important recommendations, but some of them are really already existent in our law, maybe in terms of translation or lack of expressing oneself. There might be lack of communication leading to these deficiencies. But these recommendations, especially we looked at certain recommendations, and in order to take them into account while preparing the legislation, we have no hesitations. The professor already talked about it. In the year 2000, the Ministry of Justice provided an approval on establishing a criminal science committee. The science committee has been carrying out its meetings, tens of meetings. The aim of this committee, is to review the legislation, the Turkish Penal Code and the Practice Code, and for 15 years the improvement recommendations are being identified, and the committee is working on this. As you know, in 2005, the Turkish Penal Code and other legislation was put into force, and in order to evaluate the implementation, the Science Committee was set up. And while the Science Committee is carrying out its activities, there are some actions both in the Human Rights Action Plan and Justice Action Plan. So they are providing their support in terms of implementation and review. While the Turkish Penal Code is being discussed item by item, when we come to Article 80, including the recommendations from this panel and including Greta recommendations, they will all matters will be discussed, and Article 80 will be further improved. That is my hope. Well, regarding Article 80, the activities of the Scientific Committee and the activities of the Ministry of Justice can be considered as following. As you know, in 2018, in our country, the new presidential system has become in force, and due to the specificity of this system, lawmaking has changed. There's Article 88 of the Constitution about lawmaking, and the laws are proposed by the cabinet and the members of the parliament. But with the referendum that was carried out in 2017, there has been an amendment in the Constitution, and this regulation has now been amended. According to the new regulation, only the members of the parliament are authorized to propose laws. Therefore, the ministries or the government, let us say, does not have a practice as preparing draft laws and presenting to the parliament. The ministries only work on the legislation. They develop the legislation that should be, we can consider it as a report, and the members of the Turkish parliament, if they agree with these reports, it becomes a law after being adopted by the parliament. So this process has changed, and we need to convince the legislative in that regard. So the basis and legal basis, justifications, and impact analysis of that report should be made very well. And the scientific committee is there to fill in that gap, actually. They are carrying out their activities in that line. So the professor already mentioned normative activities and other normative assessments, and other panelists talk about the challenges in practice. And of course, the first step in anti-trafficking is legislation, of course. And without a legislative arrangements, you cannot criminalize anyone with a provision in a convention. Of course, the legal arrangements should be perfectly in place. But after legislation, the second step is implementation. At hand, we have an article, good or bad. We talked about its deficiencies, but the effective implementation of this article should be the first step right now, and then we need to improve the legislation. Well, I seem as a legislator who is putting the ball in the court of the practitioners, but this is the case. Of course, we need to facilitate the difficulties in collecting evidences, and the Department of Victim Services is there to fill in this gap in practice, and hopefully we will obtain the necessary result there. And of course, the economic structures of the countries that are better off in terms of welfare are more effective, are more attractive. We have wars around us, conflicts, terror, and these factors make our country more attractive, and we will see this crime more, and we will work on it more in the future. That is my idea. And as the Director General of Legislation, I would like to thank you all for your contribution, and thank you for your attention. Thank you. We would like to thank Mr. Abuzer Yazıcıoğlu, Deputy Director General of Legislation in the Ministry of Justice. Well, Director General talked about the overall background of criminal offenses regarding human trafficking. He mentioned that this is criminalized and it is envisaged in Article 80 of the Turkish Penal Code. Of course, since this is a new criminal offense, in terms of developing the legislation, there might be some needs. He mentioned this factor, and as the Ministry of Justice, they are working with the scientific committee, and in general, when the time comes, this article can also be reviewed. In the Human Rights Action Plan regarding amendments in the legislation, there is an activity that has been foreseen, and other activities are more towards practice. He underlined these elements as well. In this context, in the scope of combating this crime, many elements should be taken into account, he said, and statistics. When we look at the statistics about this crime, the numbers may seem low, but this is due to actual situations, and the statements of the victims might not be that frequent about this criminal offense. That is why there are some challenges in collecting evidences regarding this criminal offense. And in this sense, regarding Greta recommendations, they are going to review again these recommendations, and since the government system is now a presidential system, the draft laws are no longer presented to the parliament by the cabinet. These are done through law bills, proposals of laws. That is why it is under the authorization of the Turkish parliament. Thank you very much for all these assessments you have made. Now we have 10 minutes left, and I would like to now receive questions from the participants if there are any. You have the floor now. Please go ahead. Microphone, please, for the speaker, for the interpreters to hear. Microphone, please. Thank you very much. I now have the microphone. Well, we went to Sweden about human trafficking. The volcano erupted then, and we had to stay there, and we had the opportunity to review these issues at length. So regarding this convention about benefiting from victim services, criminalization of this, and the action convention, so criminalization of the person who purchases the sexual exploitation service. I do think that it is not possible in Turkish law, and as a result of the interception of telecommunications, when you give this decision, you can identify this from the interceptions, and you see that evidences can be there. Even celebrities, famous people, ordinary people, since I lived in Ontario for long years, we can see that they are purchasing this service. However, in our country, it is not regulated as an offense. In Sweden, it was sanctioned with a fine around 200 euro. I wonder your personal opinion. Purchasing the sexual service, should it be criminalized in Turkish law or not? Well, this is a very sensitive issue, not only in terms of sexual service, but we can consider, for example, labor supply that is supplied to the labor force market. Well, Article 19 talks about benefiting from the service, so using this service. It doesn't matter, it is in exchange for something. First, let me talk about the service, and then I will come back to this. For example, you are looking for a babysitter, a stay-in babysitter. 2,500, 3,000 lira can be paid for a babysitter, but you pay that babysitter 4,000 lira. But that person actually is a victim of human trafficking and is being exploited. Can you be criminalized in this case? No. Why cannot you be punished? Because if you look at Article 117, it explicitly says that you give some money in exchange for their service. If you pay that person 500 lira, lower than the labor deserves, then yes, you can be punished. So the service that is being provided consciously with consent is something else. I do believe that this is an area that is related to sexual freedom. That is something else. But if Article 19 is going to be reflected in the Turkish law, we have to be very careful. Because I'm sorry, two sides are faulty, let's say. If you do not hold the stick from the middle of the stick, two ends of the stick could be dirty. Your hands can get dirty. So you have to be considering all these people, if they are victims of human trafficking or not. At the moment, we are facing with a group of migrants. I'm not talking about the term migrant as a legal term, but these people are here and they have to provide services, and people are using these services. So at the moment in our country, there are people providing services to live. They are included in the labor force, and if they entered the country illegally, it would lead to people not using their services, not procuring their services. That would lead to a violation of human rights, because these people need to provide services to live, to survive. Maybe we can reflect Article 19, but then in the future symposia we will be discussing that irregular migrants, refugees, illegal migrants, people smuggled, cannot work in the labor force in Turkey. They cannot earn money. How are we going to integrate them into the system? That would be our next discussion topic if we did that. Well, I wanted to ask you from one aspect, actually. There it says that the crime would be pushed underground. and its visibility would diminish, and seeing the crime would also diminish. That is why they consider this. If you criminalize purchasing sexual service, you are going to make it more difficult to fight against human trafficking. Actually, that was my idea. Yes, it would be it would become more difficult, but on the other hand, the organization, if they are profiting from this service, you have to confiscate these assets. I mean, there is that other aspect in terms of organized crime. Any other questions from the floor? I guess not. Do we have any questions? Please go ahead, ma'am. Thank you very much. From DGMM, lawyer Gamze Gülçakır. In the action plan, Professor, you know, in the Human Rights Action Plan, there are three activities about combating human trafficking. The first one is reviewing the legislation. The other one is about training for judges, prosecutors, and law enforcement officers. And the other one is actually about measures to be taken in the labor market. Well, as DGMM, we already, as mentioned by the Colonel, we, in the previous Council of Europe project, as DGMM, we initiated the HELP program in Turkey. We translated the HELP training program in Turkish and we adapted it. And both in Gendarmerie and in our Director General, there are various trainings that will be provided, that will continue to be provided to DGMM and Gendarmerie under the scope. And this activity that is under the responsibility of the Ministry of Interior is fulfilled in this way. The other part, about the labor part, the ministry has correspondence with the relevant ministry, the Ministry of Labor and Social Security. They are going to have joint activities regarding this action. Thank you very much. That was my comment. Thank you very much. Please, okay, go ahead. I want to reply to this comment. The administrative two activities regarding the practice in the action plan do not have a certain duration. I wanted to highlight this. Training is not a once-off training. This is going to be continuous because the people who are working in these areas change all the time. They are appointed to other provinces or they circulate, so this training activity should be continuous. This is not a once-off activity, so it will continue afterwards as well. I just wanted to highlight this. Thank you very much. Well, the three activities in Human Rights Action Plan. The first activity about the review of legislation is under the responsibility of the Ministry of Justice. Other two activities regarding training for judges and prosecutors and law enforcement officers, regular trainings will be offered and guiding principles will be drafted. This is under the responsibility of the Ministry of Interior. And in terms of the law enforcement officers and in terms of judges and prosecutors, it's a training of judges and prosecutors under the responsibility of Ministry of Justice. And the last activity about measures necessary will be taken effectively for the protection of victims of human trafficking and the inspections against unregistered employment will be increased. This is again under the Ministry of Labor and Interior. So the implementation of the Human Rights Action Plan is totally dependent on the meticulous work of the responsible institutions. And within a 4-month period, as the Ministry of Justice, since we carried out its secretariat, we held a meeting with all responsible institutions and we talked about how data will be entered and how responsible organizations will cooperate with other organizations and ministries.
Gelmesi hususundaki Cumhur
And of course, there is a circular of the presidential office to contact the relevant institutions. So we will start seeing the outputs of this in the shortest term possible. And I do hope that all of the institutions responsible for these actions will undertake the relevant steps, because Human Rights Action Plan is the main policy activity of the government in the area of human rights. And this is actually including a lot of activities that directly affect our lives. If there are no further questions, I would like to thank the panelists, and I believe that it's been a very beneficial panel indeed. Especially our distinguished panelists provided very valuable information, and we made an evaluation in the context of the Human Rights Action Plan. So I would like to thank the distinguished participants who have contributed by way of asking questions. I do hope that the panel and the future sessions will be beneficial in the context of this summit, and greet each and every one of you. Thank you. Thank you very much. We have now come to the end of session 4, and we would like to thank Mr. Yakushik, who is our moderator. And we would also like to thank the distinguished panelists on the evaluation of the particular article of the Turkish Penal Code. Thank you very much. As of 2 o'clock, 2 p.m., we will continue the afternoon sessions. We will have 2 more sessions in the afternoon. And until then, we have the lunch break. Bon appetit.
es su fruto. Ay, ay, amor, que yo solo quisiera saber qué rayos habré visto en él, si al cabo solo queda el dolor. Será el aire que te das, moreno, que bebí la pócima de tu veneno, o tu forma de mirar que nubla mi voluntad. Será el brillo de tu voz serena, dulce melodía que quita la pena, o tu forma de reír al compás de mi latir. Ay, ay, Señor, si yo solo quisiera saber qué es lo que habré visto en usted, si al cabo solo queda el dolor. Será el aire que te das, moreno, que bebí la pócima de tu veneno, o tu forma de mirar que nubla mi voluntad. Será el brillo de tu voz serena, dulce melodía que quita la pena, o tu forma de reír al compás de mi latir.
Laissez-moi vous dire ces mots. L'amour est le pire, l'amour est le pire des mots. C'est une agonie, une maladie, ignorée du corps médical. L'amour fait mal. Laissez-moi vous dire sans fin. L'amour est la pire, l'amour est la pire des tares. Lorsque goutte à goutte il sème le doute, que ce soit physique ou verbal. L'amour fait mal. C'est un mal encore inconnu dont on ne sait rien à ce jour. Et l'on dit dans les instituts que seul l'amour peut sauver l'amour, mais aussi, laissez-moi vous dire qu'un jour, on peut le maudire, l'amour. Car lorsqu'il déverse ses folies perverses sur la santé et le moral, l'amour fait mal. Laissez-moi vous dire, enfin. L'amour peut séduire, très bien. Mais passer le charme vient le temps des larmes. Et parfois
Bana mı
le geste
geliyorsunuz?
fatal.
Onu anlamaya çalışıyorum.
L'amour fait mal. Laissez-moi vous dire ceci. L'amour peut détruire la vie. Pour quelques je t'aime, combien de problèmes, de longs procès et de scandales. L'amour fait mal. Car les amours comme le feu qui brûle dans la cheminée laissent témérer peu à peu, finissent en cendres et en fumée. Et pourtant, love amour libre ou à mort.
Tamam mı acaba panelistler?
Distinguished guests, we now start the fifth session of the summit on counter-human trafficking, and we will be talking about victims of human trafficking in the context of irregular migration. I would like to invite the migration expert from DGMM, Mr. Ekrem Emre Çölyen, as the moderator of this session. And I would also like to invite the panelists, Mr. Tommaso De Cataldo, Program Coordinator from IAM, and migration expert Ebu Bekir Kurt from DGMM, and likewise migration expert Mr. Ahmet Küçükikiz from the same institution, and the Provincial Department of Migration from Edirne, Provincial Migration Expert, Mr. Yahya Yıldırım. Mr. Çölyen, the floor is yours. Hello, and once again, I would like to say thank you. This is an important summit on human trafficking, and in this session, we will be talking about the victims of human trafficking in the context of irregular migration. Foreigners' entry into our country through unlawful manners, their stay and their exit from our country is defined as irregular migration. And as we have been following through the national and international press, this has been increasing the pressure on our country. And as a result of this increased pressure of irregular migration, identifying victims of human trafficking and their protection after identification is crucial for our struggle against irregular migration. And this is why we wanted to tackle this particular issue in detail in this session. And we will be talking about these topics with very distinguished panelists. Firstly, we will be listening to the program coordinator from IOM, Mr. Tommaso De Cataldo, with whom we have been working in a very productive way for years. Mr. Cataldo is going to talk about the relations between human trafficking and irregular migration, and is going to share the perspective of IOM with us. Without further ado, I would like to leave the floor to you, sir.
Thank you.
Dakika olarak belirledik, onu da belirteyim.
Okay, 10 minutes. Thank you. I will be brief. 2 years ago, DGMM we cooperated with DGMM to prepare a study on human trafficking and forced labor. Yesterday, we spoke a lot about forced labor, and it was an interesting study. Now, regular migration is a complex phenomenon. So basically, migration management is the management of entry, stay, exit of foreign nationals. So, and irregular migration happens in this context, and there are various typologies. I will focus on smuggling in migrants and human trafficking and victims of trafficking. Now, the smuggling migrants and trafficking human beings are distinct crimes, but are adjacent crimes. In the first case, there is the consent of the migrant. In the case of human trafficking, the consent is extort or is not necessary or sought by the persons that are exploiting. And then today we heard about from Mr. Aki Doğan the issue of consent, but also the issue that when they were working in Antalya at the beginning, the stakeholders were saying anyway there is consent, and so there is no problem. It's not a crime in the sense. In 2007, IOM described the mechanism on how smuggled migrants can become victims of human trafficking. Often victims of human trafficking starts as willing smuggled migrants. They seek the assistance of these organizations to leave the country and go to another country, basically. Now, if the smuggler continues to control the migrant in the country of origin and exercise forms of exploitation, then there is a vulnerability to become a victim of trafficking. Or in the case where there is no connection between the smuggler and then the organization or the individual that is controlling or trying to exploit or exploiting the smuggling migrants. So having said this, I would like to say a brief story, try to depict a picture, basically. We have the mechanism that I described, and there is the element of consent of the smuggled migrants. Then there is the perception, no? And this is what came out from our joint study. So basically, when in the joint study they mentioned at the beginning of human trafficking, there was a need to inform the various stakeholders that trafficking for the purpose of prostitution is a crime, the consent is a complex issue, etc., etc. And now basically there is a general awareness about this. And we found in the field from the stakeholders that they're saying, yes, the smuggling migrants accept living working conditions, suboptimal working condition, but there is consent, so this cannot be considered a crime of human trafficking. And here kicks in the vulnerability, because from a study that we did again with DGMM on migrant vulnerabilities, we noted basically on solid methodology that migrants, when they reach Turkey through the Afghan route, I'm talking about the Afghan route because it's more structured, are already vulnerable, various types of vulnerability, socioeconomic condition, psychological conditions, etc., etc. And the question raises, can this person really decide to give a consent, a conscious consent to the working conditions? And analyzing this is important because can detect one if is a victim or not, and then if there is an organization behind this, and this is extremely important because it's a very structured organization, and see what are the relations between smuggling and trafficking and how this evolves. I can give you, if you imagine a slope, then the regular migrant worker that comes here might work in exploitative conditions which are not trafficking, but if is very unlucky, would find himself or herself at the end of the slope and as a victim of trafficking, no? Like an Afghan that ends up in Istanbul. This can happen everywhere in the world. An Afghan that's in Istanbul and works in the recycling sector, for instance, and sleeps in the warehouse and eats one time of day, and that is all the payment that gets. Another typology of cases when the person is at this level of a slope, yes, is exploited, like a case that we had where this gentleman agreed with a farmer to take care of 5 cows, and then he started working, but he found out that the farmer gave him 10 cows to take care of, so he had an argument with the employer, the small farmer, and the small farmer decided to beat up the gentleman, take away the passport from them, and continue the exploitation. And then it was thanks to DGMM and the intervention, also the police, extract. So just to conclude, it's always important to have this interdisciplinary approach and look at the dimension of vulnerability of the individual as a tool that would contribute to identify if is an effective victim of trafficking, and then if there is coercion, etc., etc. Thank you very much.
Thank you very much to Mr. De Cataldo for this very valuable presentation. You mentioned the difference between migrant smuggling and human trafficking, and you indicated that there has already been an awareness with respect to the prostitution, but we really want to create an awareness in relation to human trafficking. This is one of the preliminary targets we have. Now I would like to leave the floor to a colleague of ours who has worked in human trafficking for quite a long time and who has been working in the Department on Protection of Victims of Human Trafficking, to Mr. Ebu Bekir Kurt. He's going to paint a picture for us about the combating human trafficking. Mr. Kurt, you have 10 minutes. Thank you very much. Emre has already introduced me, and thanks for his comments. As he has mentioned, in 2014, with the establishment of the DGMM, I started working in the Department of Protecting of Human Trafficking Victims. I worked there for 5 years. Now I'm working in the head of department responsible for foreigners. During this 5-year period, especially in relation to the integration of international standards to the domestic legislation, support services, and the protection of victims were the areas that we worked on. The topic of this session is the relationship between migration, irregular migration, and human trafficking. Actually, what we see in initial phases is that this has been started to be shaped by international standards and international legislation. As of 2000, there has been a greater awareness in the part of the countries, and with the Palermo Protocol, the criminal framework was established. Actually, when we look at the Palermo Protocol, we mostly see provisions pertaining to the sanctions and seeing support services for victims and standard operation procedures have been lacking. And then the Convention of the Council of Europe for combating human trafficking has been set forward, to which we are also a party. When you look at this, you will see support services for victims, access of victims to such services, and also provisions if these are in a foreign country. Before I came here, I also did a research on legislation in relation to irregular migration and human trafficking. Actually, when we look at the general, there is no specific or detailed provision pertaining to irregular migration and its relationship with human trafficking. These are mostly put forward in the awareness-raising activities of these institutions and the guiding principles, and countries develop their policies in line with these. When we compare international law with our own legislation, actually in line with the international law, the conventions to which we are a party to, like the Palermo Protocol and the Convention on, of the Council of Europe, we see that we have actually integrated 100% of the responsibilities of the state to the domestic legislation. And when we have made an even deeper research, we have seen that we have a much more comprehensive service pertaining to the victims. To give an example, in our regulation, which governs the people who unlawfully obtain income in our country before deportation of such individuals, we have actually made it compulsory that they have an interview of victims of human trafficking. And this is a good example that could be put forward in the international arena. Plus, when we look at this in many of the conventions, we see that residence permits are related to the cooperation of the victim with the relevant authorities. But when we look at the practice in our country, there is no such obligation. Currently, we have a certain time duration before they're identified as victims. And when they're identified as victims, we provide them a residence permit, which could be extended up to 3 years. So in relation to human trafficking, we have, in my opinion, quite comprehensive legislation. Our problems might be stemming from some of the loopholes in the practice. Human trafficking at its core is a criminal offense which is quite extensive, and you can come across it in every area. For instance, in a health care institution, or when a foreigner obtains a residence permit, or when it's concerned with labor or forced labor, we can actually, or we should actually think that we can always come across to victims of human trafficking. I would like to present two proposals. One of them is actually concerning an activity. We need to take them under two headings. One is awareness raising. Secondly, developing standard operational procedures. In terms of awareness, in respect to irregular migration, we come across to the reality that many irregular migrants are not aware of the concept of victims of human trafficking. Actually, when they're in the removal centers or when they're being deported, the people are subject to the actions of human trafficking, but because they do not know what human trafficking is, they cannot convey this information to the relevant authorities. So awareness raising is crucial in such activities. In addition to this, we need to develop standard operational procedures. As I have mentioned, it's not clearly indicated in the legislation, and it might not be healthy to go into that much detail in legislation in the first place. And in relation to standard operational procedures, identifying a victim of human trafficking requires specialization. We do not overlook this fact, but there are certain things that should not be left to the initiative of the appointed personnel or to the people in general. The law enforcement officials, which has the first contact with the irregular migrants, until they are sent back or deported to their country, the standard operation procedures should be clearly identified one by one. What kind of a benefit could this bring? We will be increasing the number of interviews for victims of human trafficking, identify possible victims, and thus guide them to support services. This will be an immense contribution because I have mentioned that in many areas there is a lack of awareness, and this is an important obstacle before us to conduct an effective fight against this phenomena. Just in a little while, our colleague from Edirne will be talking about the procedures, etc., as to what could be done. All of these activities have been initiated, and we, as the head of the department, we are taking steps to develop them further. Another important issue is preventive measures at the border gates. In many conventions, this has been made obligatory for many states party. The fact that we have an immense migration flow in the borders, and especially Istanbul Airport being used as a transit area. Under such headings, I do believe that the indicators pertaining to human trafficking should be put forward, and we need to develop certain systematic mechanisms. Because in the past, we did come across two examples about this. For instance, we identified a victim who was taken from Colombia using Istanbul Airport as a transit and going to Thailand. We were actually working together with Emre, and the fact that the Colombian authorities provided us information about that while he was transiting from Istanbul Airport, the law enforcement officials identified him and conducted the relevant transactions. As I have mentioned at the beginning, we can come across the victims of human trafficking at any given area. Our main aim is to put this into a certain systematic operational procedure, and in this we expect the contribution of all our citizens, because the concept of human trafficking is an extensive concept. The Ministry of Labor, the Ministry of Family and Social Services, law enforcement, migration management authorities, NGOs, and international organizations need to provide service in such areas. I would like to thank you for your patience, and if you have any questions, I'll be more than glad to answer them.
Çok teşekkür ediyorum Ebu Bekir Bey gerçekten.
Thank you very much. In a very short time, you've talked about main topics of human trafficking and its relationship with irregular migration. And you took me several years back. Let me tell you, I was on the visa group. I was in charge of transit crossings, entry and exit, and Mr. Kurt came. He was excited, and I couldn't understand. And I said, we would do anything necessary. And he was so excited. Now I understand that we were not aware of the importance of and complexity of the issue. But since I've been working in this field for a couple of years now, now I understand how to stop and prevent cases that might turn into human trafficking. Thank you very much. I now would like to give the floor to provincial migration expert, Mr. Yahya Yıldırım, who has been working on migration, irregular migration, foreign terrorist fighters. Mr. Ahmet Küçükeskes, excuse me. Thank you very much. Before I start, I would like to emphasize two things. Tommaso said something very important. He said when irregular migrants come to Turkey, they are already quite vulnerable and fragile. And Mr. Kurt also said that it is important to identify the victim of human trafficking anywhere. So I'm now going to talk about irregular migration, and you will understand at the end of the presentation how important these two statements are. As said before, we're talking about migrants who illegally enter our country or who are trying to leave our country illegally, who work without a work permit, or who come to a country illegally and stay there illegally. So this is the definition of irregular migration, and those people are called irregular migrants. And there are around 500 million migrants in the world, and 250 million migrants, and 124 million of them are women, and the rest are mostly children. From the end of the Second World War until the collapse of the Soviet Union, we do not see any irregular migration, almost none. However, in 1990s, we're talking about combating human trafficking or irregular migration. With the change in the security perceptions of countries, combating irregular migration and human trafficking comes to the fore, and we see irregular migration flows to many countries since then. In the 21st century, irregular migration has become a global threat that also nurtures terrorist organizations and other crimes. And there are many impacts of irregular migration, but the three main impacts are here on the slide. One impact is economic impact. First and foremost, we need funding and financial means to combat irregular migration. For instance, let's say the Coast Guard is on an operation and there's a boat in the Aegean Sea, and once that operation starts, it's quite costly. Even you run that operation with one boat, or when you deport an illegal or irregular migrant, you pay for the costs and expenses, or loss of tax income due to illegally working irregular migration. There is also a criminal impact of irregular migration. First of all, terrorism feeds on this, and theft, attacks, assaults, and prostitution also increase with irregular migration. Maybe this is a result that is brought along by that fragility or vulnerability, as Tommaso said, because people feel desperate, they don't know what to do, and then they are involved in certain crimes. Another criminal impact is drug smuggling or migrant smuggling as well. And it also has a socio-cultural impact. This can be seen in some social conflicts in some societies. Societies do not embrace or welcome migrants. And after 2000s, this approach has radically changed, especially in Europe, because unfortunately, irregular migrants are now seen as potential criminals, and communities and societies do not want them. Migration actually is the world's destiny. We see there is migration from Indonesia, Malaysia, between the US, Mexico, and between Colombia and Venezuela. You see the irregular migration routes on the slide. As for Turkey, and I'm going to be quick since I only have 10 minutes, we have more than 5 million foreigners in Turkey. More than 3.5 million are Syrians, and 1 million are those foreigners who have residence permits, and the rest are applicants. And this is mentioned by Mr. Kurt. So DGMM is trying to manage a vulnerable population of almost 5 million. And there is this also is one of the sources of human trafficking as well. So these are the regular migration routes to our country. There are many causes of irregular migration: economic reasons, flight from pressure, oppression, life-threatening situations. However, more than 95% of migrants coming to Turkey are coming because of economic reasons. And especially after 2000s, there is an increase, significant increase in irregular migration. It has reached up to 450,000. Then with the pandemic, it went down to 120,000. And as of today, we have captured 70,000 irregular migrants. You can manage irregular migration in two ways. Irregular migration should not be seen as a national matter, and therefore we have to face irregular migration outside our borders. For instance, some countries sign readmission agreements with other countries and try to make this migration a problem of the other country. Another measure can be using effective visa regimes, or setting up walls, or helping neighboring countries to set up erect walls. And another approach is to accept irregular migration as a fact and try to manage it. And I will be finishing in 3 minutes. Turkey actually has a policy that is based on seeing irregular migration as starting in the country of origin and ending in country of origin. So we try to solve the problems in the country of origin that gives rise to irregular migration. What are these countries? For instance, Afghanistan, Pakistan, Algeria, Iran. So we have high-level contacts with these countries in order to remove the problems in those regions and in order to make those countries more stable. We also reevaluate visa regimes with certain countries. And we also are in contact with countries on the migration route. The main element in combating irregular migration is, of course, border security, and we try to improve it. And those irregular migrants who enter Turkey in one way or another are deported. In 2015, the capacity of our removal centers was 1,740. However, today we can accommodate 16,000 irregular migrants in the removal centers, although we have increased. In addition to increasing the capacity of removal centers, we have made certain agreements with airlines, and we collaborate more effectively with law enforcement as well. In addition to deportation, of course, it doesn't end with deportation. We are therefore implementing policies to make sure that the deported migrant readapts to his own country. Therefore, we have certain return practices, and we collaborate with the authorities of the country of origin as well. I should stop here, but before giving the floor to the next panelist, I should say that 450,000 people captured in 2019 are 450,000 human beings. When you talk to them, when you have communication with them, you see how difficult their position is. When you have interviews with 450,000 people, and we really communicate with them, we can identify potential victims of human trafficking. 450,000 irregular migrants were captured, as I said, in 2019, and during the interviews, potential victims were identified and saved. And Mr. Yahya Yildirim is one of those people working with irregular migrants, and I would like to give him the floor. Thank you very much. You've talked about irregular migration, migration routes, the profile of foreigners in Turkey, and what Turkey does in order to combat irregular migration. Thank you very much. I now would like to give the floor to Mr. Yahya Yildirim, who is a provincial migration expert. He worked both with human trafficking and irregular migration, and maybe he can go into the details of what the migration officials are doing for irregular migrants who are put in removal centers. What do you do in certain provinces? Maybe you can go into the details of the actual practice. So what do you do? What are the operational procedures? What do we lack? Since you're working in the field, we expect to hear from you more practical issues. Thank you very much, Mr. Chairman, distinguished participants. I'm in charge of irregular migration in the province of Edirne. For the last 2 days, many panelists and speakers shared with us their views both about legislation and practice, and I'm going to give you information about what we do in the field. A foreigner, a foreign national who's an irregular migrant, when he is captured by law enforcement, and once necessary procedures are completed, this foreign national is handed over to us. First and foremost, we have a preliminary assessment form. Psychosocial workers fill in this form together with the irregular migrant. If they see that these irregular migrants have special needs, then they belong to the special needs group and are catered for accordingly. And as provincial migration experts, we then have interviews with irregular migrants. And we do not make a distinction between irregular migrants who have committed crimes or who have not. At the first stage, we're not interested in any crime that they have committed. First and foremost, we try to understand why they came here. We try to make them tell their story. There are specific techniques for them. One is the peace model. We first ask open-ended questions and then ask closed-end questions. If the irregular migrant fits to the description in paragraph C and G of Article 54, then that irregular migrant becomes a potential human trafficking victim. Or sometimes we see the physical traits such as bruises, etc. Or sometimes you see the psychological signs. The migrant tries to tell you a lot in a very limited time, and he or she tries to talk about everything he has experienced. This is also a sign. Or you see migrants who remain totally silent. Or sometimes some migrants ask for support from interpreters, though they speak Turkish. You ask them what their name is, and they do not want to respond to that question and try to use the interpreter. All these are signs. When we see these people, we have another interview with them because we believe that they might need either international protection or they may fall victims to human trafficking. Another indicator, another sign is communicable disease or contagious diseases. We want to see the medical report of certain migrants because if there is such a disease, this is also an important sign because these people are forced to be together with so many people that they can catch these contagious diseases. If they have an alcohol addiction or a drug addiction, we also pay attention to these facts. Maybe they're not always victims of human trafficking, but we take all these into account in our interviews. One case that we've seen in Edirne, under normal conditions, we shouldn't have had an interview to understand whether she is a victim of human trafficking or not. She was from Ukraine and she just violated the visa regime. I mean, it was just a simple case. But then we had an interview with her and I talked about the interview technique. One very important question is, what is your plans for the future? Before the end of the interview, we ask this: what do you want? What are your plans for the future? We asked this question and she said, my child is sick, so I'll go back to my country to have her or him treated. And then I asked what was wrong with his child, and she said her child had hydrocephalus. And we researched the disease on Google, and then we have shown the picture, one visual to her. And she then started crying. And she started telling us everything. She was working as a masseur in her country, and in order to pay for the treatment of her child, she came to Turkey. She decided to sell her kidney, and she used a social media account to contact people to sell her kidney to, and she came to Turkey to sell her kidney. And she was at the hospital. Tests were being run, and then she wanted to go back. She decided not to donate her kidney. However, those people paid for her travel, the hotel accommodation, etc. So they threatened her, did not let her leave, and she had to stay. But then doctor got suspicious at the hospital, and law enforcement then stepped in, and she appeared before us. So in this case, everything starts with consent. She comes to Turkey to sell her kidney. We might assume that there is consent. However, we don't believe that she has consent. Her consent was actually undermined. So we identified her as a victim of human trafficking, and we got the support of IOM as well for her to return back to her country. IOM also paid for the treatment costs of her child back in Ukraine. This is one example to one of the cases we have interviewed.
Again, during the speeches, they talked about the difference between migrant smuggling and human trafficking. We had a case, a Pakistani family is brought to our country through illegal means, and the smugglers try to take them out of the country again by illegal means. Actually, this is a subject of migrant smuggling. However, the smugglers understood that they could not take this family outside of the country through illegal means, so they closed them up, they locked them in a house, and the family's females have been raped, and they are deprived of their freedom. So the act started as migrant smuggling, however, it evolved into human trafficking. So on the field, these concepts are evolving into each other. So they came to the country by agreeing with their smugglers, they came in the country, however, within the country, they became victims of these actions. So when we are interviewing people on the field, we take into account all these signs, and when we identify that they are not victims of human trafficking, they are being processed as migrants. However, if we believe that they are victims of human trafficking, after we identify them, we process them in the scope of support to victims of human trafficking. Let me give you another example about Turkish citizens. A 12-year-old child was brought to us. This child is a Turkish citizen and was forced to prostitution. Normally, that child shouldn't come to us. This is a case that is directly that should be referred to the Ministry of Family, but due to lack of communication, the child was brought to us. Since this is a child, you cannot ask the questions directly to the child. You cannot ask the child, why are you committing prostitution? We just asked the child, how do you spend your day? And she said, I wake up, I have my breakfast, I watch some cartoons, and in the evening I go out to work. Think about it. A 12-year-old wakes up in the morning, starts the day off as all children, but in the evening she is forced to be together with people much older than her. So when we meet with such cases, we do our best to try to help them. Awareness raising activities are very important for us to be able to reach these persons. We can take them under protection. Actually, there's a very important aspect of human trafficking. You can touch the lives of people directly. You can give them a second chance. Maybe these people in the cases where they cannot get out of that situation, they cannot build a new life for themselves, but you give them a second chance. Actually, one of the basic points of combating human trafficking is this: not to protect the person, but to also provide them with opportunities to create a second life for them. In this sense, we get great help from IOM. They provide monetary resources for them to return back to their country. And when they go back to their country, they also continue their help, such as house rent help and etc., for them to go back to their normal lives. Let me touch upon a problem here. With IOM, we can meet all the needs of these persons. If it's a clothing need or if it's a food need, we can cover them. And IOM has field teams regionally. The only thing is, since all interviews all around Turkey is done from a center by one person, one officer of IOM. This is one person. And authorization of the field team in terms of interviews maybe could overcome these bureaucratic processes. And maybe it can make our combat more flexible. For children, let me talk about one case. One child, if that child is forced to crime or when they are observed, there are child observation centers. And if there are pedagogues in the province of the Ministry of Family, they also enter into interviews. So they can also be subject to human trafficking. And rather than interviewing them once again from the perspective of DGMM, we try to take part in their interviews. During that interview, at the first instance, we ask our questions in order to avoid a secondary trauma. We request to participate in their interviews as well. Maybe the legislation can be improved in that sense too. One more problem that we face in the field is the people who are working in the entertainment sector. We regularly, or the law enforcement officers regularly inspect such places. However, the people go to these places, go to these entertainment places with their legal residence permits. And when they go to these places, when the law enforcement officers go there, they say, we are here just to be entertained. And they cannot be identified. It cannot be identified that they are working there. So maybe in order to avoid such problems, when these types of operations are being carried out, in order to identify these people, more specific operations can be, targeted operations can be made, and this type of structural activities can be done in order to change the format of operations. And on the field, we observe that this crime always renews itself. And in order to combat this crime on the field, by taking into account the modus operandi of the perpetrators, we also renew our operations. For example, during the pandemic, the entertainment places were shut down, but they came to Turkey somehow and they needed to work somewhere, and we carried out operations on the field. And we have observed that these people continued working in the illegal, off-the-record places. So this is the field process. If you have any questions, I'd be glad to answer. Well, thank you very much, Mr. Yahya. We passed the time a bit, but since Mr. Tomaso and Bekir graciously gave us a bit of their time, I didn't want to interrupt you. So in terms of time, we don't have too much time that remains, but if you have any questions, we will try to answer them. You have the floor. From Gendarmerie, General Command, Anti-Trafficking Unit. The interpreters cannot hear the speaker. The microphone of the speaker is not transferred to the interpreters. The interpreters cannot hear the microphone. The interpreters could not hear the question. Thank you very much for your question. Well, actually, I was hoping to touch upon this in the presentation. When we identified people as victims of human trafficking, we have to report to the relevant law enforcement or judicial places. So we do report the crime to the prosecutors. In the reportings that we have done so far, the legal proceedings have started, prosecution has started. But when you identify victims, you have to report that as a subject of human trafficking to the prosecutors. And the judiciary starts the relevant processes for the people who are specified in the file. Yes, the prosecutor here also mentioned that, for example, when there's a pregnancy case under the age of 18, the hospital personnel notifies the prosecution, and probably the prosecutors can initiate the investigation and the prosecution. Well, the public prosecutor can initiate the investigation. Sorry. There was a decision that was adopted. In order for the investigation to start, it is under the responsibility of the public prosecutor. Of course, the instant cases are a different issue, but since this is a unit, since this is Migration Management Department, they have to notify the authorized public prosecutor's office. And of course, the public prosecutor's office has to notify the law enforcement officers. If it is a gendarmerie area, they should notify the gendarmerie. If it's a police area, they should notify the police. Thank you. Actually, what we also do in practice is that while notifying the judicial units, we also inform the law enforcement officers. We send the files to law enforcement units as well. Of course, they are confidential files, but we do inform them regarding the subject. I took the microphone, so I will try to intervene and continue. Well, Mr. Ahmet introduced the topic. You said migration and terrorism, but you didn't touch upon terrorism. So in June 2019, the first one was in Montenegro. The president of Court of Cassation and the public prosecutor and I was there. We talked about foreign terrorist fighters, and the chief prosecutors and presidents of courts of cassation of 21 countries had a 4-day seminar in 2019. Of course, this was supposed to be regular, but due to the pandemic, the second one was postponed. We don't know when this symposium would continue. But in our country, we had one issue. For example, there was a case, Nabil Fadıl, Syrian person who came to Turkey in Sultanahmet. It was a live bomb, actually. He exploded himself into Sultanahmet. Many Turkish people and foreigners died in Sultanahmet because of that live bomber. So in foreigners entering the country, not everyone who enters the country is a migrant. There should be some type of an inspection over them. So in this inspection, what type of system is imposed in Turkey in these interviews? Because Reyna bombing happened in a similar way and many people have died. So such type of incidents happening in Turkey is really relevant with our tourism, with our security. So when migrants come to the country, in the entry into the country, they are subject to interviews. I wonder about your system. Well, let me explain to you. The year was 2014, the first operational activities of DGMM. And I was in the group I was working in the group that was working with foreign terrorist fighters. Well, this shows us how in coordination we are working with. I'm seeing it for the first time, and I have been working with foreign terrorist fighters. Well, yes, when we talk about foreign terrorist fighters, this is a very comprehensive issue. But let me briefly explain. In the entry of foreigners in 2014, the head of intelligence and counterterrorism department of DG Security and the Turkish Intelligence Agency created a special team for the profiling of foreigners. A special unit was established. And in the entry to Turkey of many people, there's a preliminary review. For example, for a person, a lady wearing a short skirt was in Atatürk airport, and that lady comes into Turkey. That woman comes into Turkey, and the police officer who sees that woman holds the arm of that lady and said, please hold on a second, we have to interview you. There's only one reason why that was the case. the officer understood it from the mark in her hair, showing that she actually wore a headscarf. Then they opened the suitcase. In her suitcase, they see hijab, and they realized that she was trying to go to Syria. So we banned that person from entering into country, and that was an inadmissible foreigner. So you have a unit for foreign terrorist fighters? Well, in all around the country, there is an actively working unit working at foreign terrorist fighters. Microphone for the speaker. The specific example that you gave us is a law enforcement activity. It is an intelligence activity. Of course, in our gates, we see who is coming in, who is not, who's going out. I was talking about regular people. I'm a regular citizen, a Syrian citizen. When they enter into the country, in your interviews, can you ask questions? I'm asking in terms of questioning techniques. Can you ask them questions about understanding whether or not these are really migrants or not? Well, we have interview forms, irregular migrant interview forms, and the first interview with the foreigners is done by our law enforcement units, and they frisk them. For example, they look at their bodies, they look at marks, body marks, and behavioral patterns are also reviewed. So when a foreigner is observed, if there are also information that is sought whether or not they have bullet wounds in their bodies, for example. So you should have a strong intelligence source so that you can make up your mind. But of course, after the meeting, we can have the opportunity to talk into the details of this issue, hopefully. Yes, Mr. Prosecutor, well, in terms of mass influxes, in terms of the entry into the country of Syrians, well, Mr. Prosecutor, we have been there with all of our colleagues since 2014. There's a three-pillar system. The first step is body search, a very rough body search. Well, as Mr. Ahmed mentioned, there's also law enforcement and intelligence officers present. So that is the first step. First, body search, and then they're registered. DGMM registers the person. So there's a preliminary observation until it comes to us. And as per the directives given to us by the working group of Mr. Ahmed, we also have detailed interviews. So actually, we no longer have time, but discussions are going on very well. So if you have any other questions, we can prolong it for a couple of more minutes. Let me check the room. There are no questions. Thank you very much, everyone. Yes, distinguished guests, this was the end of our fifth session. We would like to thank our moderator, Mr. Çoryan, and our panelists, Mr. De Cataldo, and Mr. Kurt, Mr. Küçükikis, and Mr. Yıldırım. Thank you all very much for your words. And we will have another 20-minute coffee break, and then we will continue with our sixth and last session.
Sayın
Distinguished guests, we now come to the last session of the Summit on Combating Human Trafficking, which is on victims of human trafficking in the context of international protection. And the moderator of this session is the migration expert from DGMM, Mr. Ebu Bekir Kurt. And I would also like to invite the panelists. Madam Ivana Gruania will be connecting to us via Zoom connection. And we have migration expert from DGMM, Mr. Ekrem Emre Çölyen, please. We also have a migration expert, Mr. Talip Menekşe from DGMM. Provincial migration expert from the Provincial Director to Migration Management, Madam Kübra Özcan. And Madam Ezgi Özenkök from UNHCR. Mr. Kurt, I'd like to leave the floor to you. Thank you very much, distinguished participants. In the context of the two-day summit that has been organized, we have now come to the last session of the summit. Of course, in relation to human trafficking, it concerns many different institutions. And in the program that we have organized, we have come to the last session, as I said. Within the program of 2 days, we have talked about various activities pertaining to the yesterday and the today of combating human trafficking. We talked about the criminal offense of human trafficking in the national and international legislation. The victim support services were also discussed, and we discussed the irregular migration vis-à-vis human trafficking. Today, it's 30th of July, and it's the day of combating against human trafficking. And we have organized a very important two-day summit, and I would like to thank each and every one of you who has contributed to the organization. And we will be talking about now the international protection dimension in this area. As we have mentioned in the previous session, we do not see any loophole pertaining to the legislation, but with the contribution of the public and international institutions, there are certain procedures that have been established, and the distinguished panelists will be informing us in this area, and we will be also contributing. Now, Madam Ivana Rania will be connecting to us online, and now I would like to leave the floor to her.
Thank you very much, Mr. Panelist, distinguished speakers, and dear participants. Greetings from Italy. I'm really honored to be with you today, even though from a distance, as this pandemic has taught us to get used to participate in this very important discussion. We have very little time, and I was given a quite complex task that is to present to you the victim-centered approach to be adopted in relation to victims of trafficking seeking in international protection, but also to touch on the criminal dimension related to that, and in particular, how to reconcile the victim-centered approach with the need to investigate and prosecute the traffickers, which touches on a very thorny, very complex and complicated issue, that is collaboration of victims. I guess I have some 10-15 minutes maximum for my presentation, if my understanding is correct. And so I have decided to just focus on a couple of aspects that I would like to share with you. And in particular, the reason why I will touch on these aspects is because I've been working as a criminal defense attorney and immigration lawyer in Italy since 2006. And since then, I have accompanied a lot of victims of trafficking along their asylum procedures and also alongside their the criminal proceedings that related to their traffickers. So I will share with you a couple of stories that are illustrative of some aspects that I'm sure you've already debated yesterday and also earlier today. I only had the possibility to listen to a few interventions which I found very interesting. Not only I will share my personal experience, but in a way, I also want to share the experience of my country, of Italy, which is a destination country for many asylum seekers, and which was the first European country, together with Belgium, to equip itself since 1998. Therefore, well before other conventions related to trafficking and protection of victims, of a legislation, a victim-centered legislation protecting victims of trafficking and granting them residence permit, regardless of their collaboration within the criminal proceedings. And this has always been something that we were very proud of, because it was something that anticipated a certain approach that was adopted later, and which in my view was totally in line with the human rights-centered approach, a victim-centered approach that we are talking about today. I have a presentation, but I see I cannot share it because I have been disabled, but it's in English in any event, so it's not very important that you see it at this moment. Now, when it comes to the identification of victims in the context of international protection, we know that the identification is always problematic because, and it is fundamental. It is problematic because of the many implications, the struggle, the trauma that victims of trafficking go through because of the control they are under, the influence that the traffickers are able to extend over their life, not only in the country of destination or in the country where they seek asylum, which can be a different country, but also in the country of origin. The identification is very difficult and can occur at any stage of the process, of their migration process, from the arrival to the reception to the asylum procedure itself, or in the phase of pre-removal. Late surfacing as such cannot be automatically an indicator of a non-genuine status of victim of the individual who claims he or she has been trafficked. In practice, in my practice, in Italy, despite the very advanced legislation that we've had in place since 1998, de facto identification of victims occur not when they place an asylum request, but when their asylum request is being examined. And this is very much related, as far as my country is concerned, to the training and the capacity of the different officials that deal with these individuals since their arrival. Training is obviously a key. I was hearing the previous panelist talking about the importance of training of law enforcement officers on certain procedures. And this applies exactly also in the same way also when it comes to the identification of victims of trafficking who are asylum seekers, who are reaching, in our case, the shores of Italy in the context of mixed migration flows. The training, as I was saying, is fundamental. In this respect, I'm very happy that in this panel we have also a representative of the UNHCR, because their manual on the identification of victims of trafficking is very useful, is one of those guidelines that all practitioners dealing with asylum seekers, but also with migrants in general, because asylum seekers are part of mixed migration flows nowadays, should be familiar with. That also wipes away a number of myths or misunderstandings about who the victims of trafficking are and what they look like. We have a standardized, and when I say we, I always refer to my national experience, a standardized image of a victim of trafficker, a woman within a certain age range, trafficked for the purpose of sexual exploitation. But in fact, there are a lot of different categories of victims of trafficking, which are probably more difficult to detect and which are trafficked not for the purpose of sexual exploitation. In the context of international protection, and I'm sure that the other panelists will elaborate on this more, of course, when the victim is recognized as such, then there are very high chances that national authorities provide for the recognition of international protection in the form of the status of refugee or a subsidiary protection, because that person is at risk of a form of persecution, which consist in the trafficking in itself, in the risk of the re-trafficking, in the risk of victimization if sent back to the country of origin or to the previous country of destination, because that person belongs to a certain category that is could be that of women, of disabled persons, victims of domestic violence, or other group identified, for example, because of their ethnicity or social belonging. What I would like to underline is the aspect of the human rights approach to victims in the context of international protection. And I would like to share with you my experience and to leave you with one key word, which is time. Article 13 of the Council of Europe Convention on Action Against Trafficking in Human Beings calls for a very important measure, which is the refraction and recovery period of at least 30 days. In my experience, time is always key to provide not only the needed protection to victims of trafficking who are also asylum seekers, but has also an impact on the eventual participation of victims to the criminal proceedings against their trafficking, which is something which is very frustrating from the perspective of the authorities and the law enforcement officers, because very rarely at first, and when I say at first, I refer to months and sometimes years, victims of trafficking accept to collaborate with the authorities and to contribute to the investigations with their testimonies, with the provision of different forms of evidence. time and support, which is exactly the purpose of the reflection and recovery period foreseen by Article 13 of the Council of Europe Convention. I will tell you the story of one of my of the victims I followed, and her name we will call her Nice, and Nice was the typical Nigerian woman being trafficked to Italy for the purpose of sexual exploitation. She sought asylum immediately after receiving in Italy, while still within the hands of the traffickers. And this is something that we want to bear in mind, because often the traffickers actually hope that the victim gets a form of international protection to benefit from that international protection, because a victim of trafficking who is still within the hands of the criminal organization, who has an unlimited residence permit, who has a valid passport, and who is able to travel within countries, is a very rare commodity, because it will facilitate family reunification following, for example, a fake marriage, a scam marriage, because it will help actually provide for covering up certain trafficking activities. So it will provide fuel to the international criminal organization controlling trafficking. So Nice was exactly in this situation. She sought international protection. She was still in the hand. She declined the support that she was given. She said she was living with this boyfriend. She was out of the system, etc., but she was still within the system. And she continued to be within the system, which did not recognize her asylum, the status of refugee, because she claimed that she had escaped the system, but she could not prove that there were current, real, immediate threats to her life due to her behavior. She was denied international protection at administrative level, but we took the case to the tribunal. And Italian tribunals are unfortunately famous all over Europe for their lack of speediness. So it took us 4 years for the case to go through the system, the judicial procedure. In these 4 years, her pimp decided that it was okay that she continued to work as in the sex industry, but it was also good that she got a regular job, you know, just to have a backup plan in case things didn't go well. That allowed extra income to reach the household, and of course her pimp was very happy about that. Nice was lucky enough to get employed in a family farm, where a lot of other migrant women, foreign women were employed, where the employer was an illuminated man who took really care of all these people, men and women who were working for him. And because of the nature of the work, because of the ties that she was able to establish in the course of her working relationship, and this is where time comes into play, eventually she realized that what was happening to her was not acceptable, was a violation of her dignity, was non-respectful of her. She was, at least for part of the day, under slavery, under forced servitude. she was asked to do things that she didn't want to do. And it was only because of the time and the informal support that she received. She was very lucky from the environment she was working in, that she was able to realize the human rights dimension that she had always neglected or ignored, because many of the victims of trafficking don't know they are victims of trafficking. They are just used to being abused since a very early age. And that's the way life is. It is tough, but you cannot change it. I remember when we had the hearing in front of the judge wanted to hear her, and I supported her through the whole procedure, also of maturity. And she said something that I was not aware of. And she said to the judge, was asking question about her boyfriend. And she said, last month, I left him. I realized that I don't need him to tell me how much I am worth. I learned in these 4 years of life in Italy, working in this farm, that I'm worth as a person. And so I decided that I could cut with my previous life. And the judge was really astonished, because this was something that was obviously very genuine. That came at the end of a process that she had gone through. And in this case, time was important. She was given, if I remember correctly, the 30 days of recovery and reflection period that are foreseen by the law. But that was not enough for her to mature certain decisions. And the type of support that the authorities were able to give her during that time frame was not sufficient, was not culturally adapted, did not take it, was of a standardized type. And not only she was able to live her life as a human being worth of dignity. By the end of the process, she eventually was recognized the status of refugee, but she became also willing to participate in the criminal investigations against her traffickers, something that she would have never done 4 years before, because she needed to be empowered. So time and trust, in my case, and this is one of the many cases I had, were key. And the trust, you only obtain it if you provide adequate support, not merely on paper, but support that takes into consideration, for example, the low literacy rate, the difficulties, the trauma of these individuals. So time is not only fundamental for providing a protection of victims within the international protection system for the purpose of asylum, but also to ensure that these victims, whose participation is key for the success of criminal investigations, are willing to participate in them, thus making them successful. I think I exploited even more of the time that was allocated to me. So I thank you very much for your attention, and I leave the floor back to the moderator. Thank you.
Thank you very much, Madame Rana. Of course, approaching the issue from human rights perspective and victim-oriented approach, you gave us examples from the activities since 1998, and you shared us what you were experiencing in the field. We are very grateful for your valuable contribution. Now we pass on to another panelist, which is from the Department of Protection of Victims, Mr. Ekrem Emre Çolyan. He will be sharing with us a general perspective in relation to the protection of victims and the mechanisms. I now leave the floor to him. Thank you. Thank you very much, distinguished chair. We have been discussing the issue of human trafficking, and I'll be briefly summarizing this concept as well as reviewing the 2 days in general, and I will also be focusing on its connection with international protection and complete my presentation. As we all know, human trafficking is, in the basic sense of the word, modern slavery, purchase and sales of a human being like a good. And in that sense, human trafficking is an important criminal offense against human rights of the individual and a big threat, but it's also a big threat pertaining to public order and security, and it's an area in which we really need to fight. We, as the DGMM and the Department of Protection of Victims of Human Trafficking, we are providing our services by increasing awareness and actually conducting activities to prevent this criminal offense. When we look at the way of the criminal offense, the most known type is actually sexual abuse and labor, forced labor. Sometimes most resources actually focus on this type of abuse. But recently, we started hearing more about forced marriage and beggary and children who are soldiers, and transplant and organ transfers are also another dimension. So the DGMM actually has 4 main headings when we are analyzing this concept. And in the area of protection, we are the eminent institution that is more active. And the department that we are working is the head of department responsible for protection of victims of human trafficking. Again, in relation to prevention, we have a lot of activities. We conduct a lot of awareness raising, and we actually try to visit all 81 provinces as much as possible. Again, in relation to cooperation and investigation, this is an area in which we partially participate. In relation to awareness, every year, as the distinguished moderator has indicated, because this has coincided with this World Day, and on this occasion, we have numerous institutions that have been presented, and they have participated one by one. This has been an immense contribution for us. I'm just going to give an example about an awareness-raising activity. Last year, we had a victim that we identified in Manisa from Morocco, and has been brought to Turkey with the commitment of getting married. And there was a photo shown. The Turkish people like their bride, and they value the bride, and they purchase you a lot of gold, clothes, garments, and she was deceived and provided consent. And when the individual came, she came across to an individual who was totally different from the photo shown to her. She did not want to accept, but the traffickers indicated that, okay, we have been hosting you, we bought your plane ticket, and she was forced. So when she was forced, she understands that she cannot escape and continues this commitment. She says, okay, let's make the preparations for the wedding, and they go out to purchase items. And this was something that was experienced in Manisa last year. When they do a lot of purchases, in one shoe seller, she benefits from a gap and attracts the attention of the sales assistant there. And because of that, she was saved. How does this happen? the person who brings her to this position, the moment they receive a phone call, she tries to explain to the sales expert that she wants to go to the police, and the sales assistant contacts through WhatsApp a friend, invites the police, and she shows a lot of shoes, etc., and starts gaining time. So according to the information, this takes more than half an hour, and then she comes, the police comes, and it's identified that she's a victim of human trafficking, and we were able to save her just because she was about to become a victim. So the taxi drivers, people who are working in the hotel, people who are working in shopping malls, they really should be included in a training. We are planning this training, and before the pandemic, in 2009, we had a lot of training activities, and we were actually unable to provide service to this section. But I do hope that as we get rid of the pandemic, in the shortest term possible, we will continue to work with these individuals. When we look at the connection of international protection and the human trafficking victims, we really have some very good activities together with the UNHCR. Madame Ezgi will be talking about the details of the activities that we conduct so far. First and foremost, we can say that victims of human trafficking are or might be an individual who is in need of international protection, but this does not necessarily mean that every victim needs to get international protection. But there could be some that are in need of such a protection. So we are talking about individuals who have been victimized in their country, and they might be going to a country in search of international protection. Again, when we look at the origin country, they might be victimized there, or they might have fled, or they might have an international protection status, and they might be victimized in the country that they receive this protection status, and they are unable to back to their origin country. And there could be different variations that we come across to in such scenarios. So I'll briefly talk about our own legislation about this in relation to the regulation for the victims. There is an article that says that people who are receiving international protection, including temporary protection status holders, might be also victims of human trafficking, and in such cases, both status could be provided to the individual. So this is actually a good regulation, but this should be identified together with the Department of International Protection. If we are to talk about these similarities, there are individuals who are in need of international protection might be similar to the victims of human trafficking or possible victims. They mostly have some money problems. They are coming from a different culture. They have language problems. So these are similarities between international protection status holders and the victims of international human trafficking. And again, in line with the training services, healthcare services, or social assistance and access to the labor market, there could be similarities between these two groups. And in our country, they really have separate rights. Their access to health rights, labor rights, and educational rights are similar. Another area where they are similar is shelter houses where victims of human trafficking stay in, and also the acceptance centers where international protection status holders and also temporary protection status holders houses. These are accommodation services, healthcare services, education, psychosocial support, access to lawyers, religious services, social assistance, security, etc., and services of an interpreter translator. Again, in line with these services, we believe that international protection and human trafficking are very similar concepts. We, as the Department of Protection of Victims and International Protection Holder Departments, we believe that in order to have a uniform approach so that the practices are standardized in 81 provinces. We cooperate with the other department. Again, with one more example, I would like to leave the floor to the other panelists. We also had another case last month. We had a victim who stayed in the shelter house and has an international protection status from Turkey. According to our legislation, the international protection status holders need to have at least a 6-month application for international protection status. For instance, if I make that application today, I cannot actually start working tomorrow. I need to stay for at least 6 months. So this victim, who was staying at a shelter house, was staying here for 3-4 months and is unable to receive a work permit, but has an employer, and the employer wants to actually get her a working permit. And if we also give a residence permit as a victim of human trafficking, we were able to resolve, was also already defined as a victim of human trafficking. We provided a residence permit, and once they have a residence permit, they can apply for a work permit. Maybe Talib could also give information about this. Those people who have international protection status, and especially if people have been victims of human trafficking, this 6-month precondition could be amended. Could it be eliminated so that we have a more victim protection approach? How would he interpret this as a person from that department? And now I'd like to leave the floor to the moderator.
Emre Bey
Thank you very much, Mr. Çolyan. He talked about the relationship between international protection and trafficking in human beings. Since we have limited time, I will quickly proceed with the next speaker. Talip Menekşe from the Department of International Protection will be talking about the relationship between international protection and migration and human trafficking. Thank you very much. Thank you very much for the kind invitation you extended to me. Human trafficking in the context of international protection will be the main focus of my presentation. Ivana and Emre actually made an introduction to this issue. They talked about the intersection points between these two. And I will mostly dwell on international protection. Migration, refugee, asylum, these terms are used very frequently in our day and age. International protection, therefore, has a bigger significance today. According to the UN data, there are almost 100 million people in the world who are displaced, and 40 million plus of them are internally displaced people, and the rest are people who cross borders and seek asylum in other countries. Asylum system is a system that protects human dignity, and international protection is actually a system that protects human beings with dignity. Since this system is not available or in place in the country of origin, people seek for asylum in other countries. 20th and 21st century are known to be the age of migration, and we have so many research. However, before proceeding with international protection, I would like to talk about some terms. Asylum. Asylum has a long history. However, it has been internationally recognized, especially after the Second World War. When we talk about refugee law, international protection, and asylum, the Geneva Convention draws the framework for these terms, which is was followed by New York Protocol, and these were instruments that were generated in the aftermath of the Second World War. Before that, there were some regional regulations. However, they were not internationally recognized and accepted. 1951 Geneva Convention and 1967 New York Protocol required state parties to develop and establish their own protection systems. And until 2010, asylum, refugee, visa regimes were all tackled by the Director General of Security under the Ministry of Interior. However, with the introduction of the law 6458, DGMM was established, and these now are handled by DGMM. The Article 3 of this law gives definitions. Regular migration is the migration to our country regularly. Irregular migration is the migration to our country irregularly, and international protection. Actually, international protection is a type of migration. Asylum seekers, refugees, people under temporary protection are all included in international protection. Since 2014, the GMM has conducted many activities. But before talking about those activities, I would like to talk about the international protection system in Turkey. If victims of human trafficking seek international protection, or those people seeking international protection for victims to human trafficking, what happens? So if you look at this slide, you see the Turkish international protection system. In our international protection system, people who are known as asylum seekers are the applicants of international protection. Refugee or people under secondary protection, these are people with international protection status. If a person flees from persecution in his own country, and before fleeing from his country, he first seeks protection in his own country. He applies to relevant authorities in the country of origin. But when he fails to find this protection, he crosses borders and seeks asylum in other countries. He then becomes a part of international protection system. If a person enters into our country crossing the border and seeks asylum, then he becomes an applicant in Turkey. He files his application, he is registered, and then this is followed by interviews. Interview is a very important phase, and the other panelists also talked about interviews. During the interviews, we listen to the person and try to learn his life story. And at that point, maybe that person has not been identified as a victim of human trafficking yet. However, based on what he tells us, we can identify him as a victim and refer him to relevant authorities. Sometimes we have interviews of 3 hours, 5 hours, or days. And in these interviews, we learn what he experienced in his own country, what happened to him while coming to Turkey, and we can also organize additional interviews with that person when necessary. In the previous session, there was a question about interview techniques. I would like to talk about this. We give trainings on interview techniques, and we teach the trainees about how they should ask the question, how they should formulate the question. We also give training about the importance of body language. When it's the victim of human trafficking, this is even more important because we are faced with a person who has been abused and he might be under oppression, pressure, or threat, and he may not be able to tell us everything. So the interviewer or the case official should be aware of this. Under international protection, victims of human trafficking are defined as people with special needs. People with special needs, according to Article 67 of our law, should be given priority in each and every stage of international protection. Of course, each and every person with special needs is not a victim of human trafficking. However, if the person who has been identified as a victim, and if that person at the same time asks for international protection, he's given priority throughout the process, starting from the registration to interview. Although the time limit for interview is 6 months, he's given priority, or his status evaluation is accelerated. Resettlement in a third country, that victim is given priority in that stage as well. Subsequent to the interview, asylum seekers, that is, applicants of international protection, are identified, and actually they're given a status: international protection, refugee, and the refugee under secondary protection. So these are the three status that are granted to these people after the interview. Refugee, or refugee under secondary protection, or conditioned refugee, are actually procedurally identical. However, there are 5 criteria. If the person is persecuted because of his race, nationality, membership to a certain group, or political views, that person is called a refugee if he comes from a European country. If he comes from a non-European country, he is a conditional refugee. And when we say secondary protection, we're talking about people who might face certain risks and dangers. So the refugees and people under temporary protection in Turkey who are Syrians have the same rights, actually. Sometimes the applicants of international protection might be victims, child victims of human trafficking, or they might be child soldiers. So if the signs tell us that they might be victims of human trafficking, we refer them to the Department of Victims of Human Trafficking in relevant provinces. For instance, we have temporary accommodation for Syrians, and we have admission centers for applicants of international protection. And in all these centers, we have specific units for victims of human trafficking. In order to have access to all applicants of international protection and to provide them with services on site, we have a project, and at the end of this project, we have opened centers in Ankara and Istanbul, and experts carry out the interviews at these centers. And we are spreading this system across the country now. We also have mobile units who are voluntary, visit people with special needs, and assist these people in situ. This project has been very useful in identifying victims of human trafficking. We have so many collaborative projects with the UNHCR as well. Training, technical workshops, information seminars are organized in order to raise awareness about human trafficking. Interviewing, assessment of evidences are some of the topics where we provide training, and we're collaborating with UNHCR. One person is displaced every 2 seconds is in the world, and 97 out of 100 people are affected in this respect. So it is important to see the relationship between international protection and human trafficking. As a DGMM, we provide many services under international protection, and Department of Human Trafficking in DGMM is also working on victims of human trafficking. And we actually are working in collaboration, and I hope that this collaboration will get even stronger with relevant legislative amendments and similar work. Thank you very much, Mr. Menekşe. You talked about the legislation in place and the procedures for international protection. We have really limited time, and I would like to apologize from the other panelists as well. Could we be a little bit even quick, because we have people among us who have to catch their flights. Now we have another expert, Ms. Kübra Özcan from PDMM, Provincial Migration Expert from Erzurum. Thank you very much, Mr. Chair. I would like to welcome each and every one of you. I am working in Erzurum Provincial Migration Directorate. I'm the head of the working group there, and I'm also in the International Protection Group in the last 7 years. Mr. Talip and Mr. Ekrem have already talked about international protection, and I'm mostly going to talk about how to identify victims of human trafficking among people under international protection. I'm also going to talk about the problems we face and the rights that we grant to these people, and then I'm going to give you some examples. Potential victims are maybe one of the asylum seekers or people under temporary protection. Protection desks or registration offices may identify a victim of human trafficking. When this is the case, that person is referred to the relevant working group for the interviews, and that working group has a detailed interview with that person, and based on his or her statement, if the interviewer sees the crime there and also the intent there, he or she is identified as a victim of human trafficking, and then this is communicated to the directorate. The directorate refers it to the office of the governor to be identified as a victim of human trafficking. When the governor's office approves this, he is then identified as a victim of human trafficking. Then his or her case file is sent to the police or relevant law enforcement, and that case file also includes some recordings of the interview and his story. If that person already has a legal residence permit, there's no need for another residence permit. In the law on 6458, people with special needs are defined as unaccompanied minors, children, pregnant women, parents with a child, psychologically and sexually abused people. And those people who are identified as victims of human trafficking are considered to be people with special needs. Once they are identified as people with special needs, what do we do? First, in the provinces, we establish committees, and these committees identify people with special needs, and this is informed to the Director General every month regularly. Since among people with special needs there are victims of human trafficking, they are given priority for resettlement in a third country. Identifying victims of human trafficking, ending the abuse, and identifying the victims of human trafficking is very important for ending the abuse and prosecuting the perpetrators, because otherwise then that victim will be left to her or his own devices. One of the biggest problems in provinces is the following. Unfortunately, public institutions still are not aware of the fact that we have the authority to identify victims. Once the victim is not identified, that victim will not benefit from the services offered to her or him. And when this is the case, the perpetrators will not be prosecuted, and victim will be victimized once again by the state or government. In order to run an efficient procedure, institutions who are likely to come across potential victims will be regularly trained, and follow-up is also important in this respect. And now I would like to give you some examples from several provinces.
The victim was born in Afghanistan in 2001, and in Iran, at the age of 14, the victim was forced to marry by the grandmother. The identification process of the victim and the victim's story is that in 2015, over Iran, illegally, this person is brought to Giresun province by the person she was forced to marry, and she escapes from the husband, and there is a protection decision by the Giresun family court, and the international protection application is received, and she is assessed as an unaccompanied minor, and as the person reaches the age of 18, status identification interviews are made, and from the stories are heard, it is identified that this person is a victim of human trafficking, and she is referred to the relevant group. The Afghani jail did not know her birth father, and since the mother marries another man, she started living with her grandmother, and until middle school she was allowed to go to school because the grandmother did not take over the responsibility of the care of that child, and the stepfather started becoming suspicious of the girl, and therefore the grandmother sold her in exchange of money to a man 30 years older than her. And the man, after she gets this child from her grandmother, forces her to come to Giresun. He rapes her, and since she resisted rape, she was beaten, and at the hospital she explained the situation to the people treating her, and the police officers captured the man, and they were brought to another province by Giresun officials. Another case is victim A. This is a baby victim. This is the first baby victim of Turkey, and the Ministry of the Provincial Directorate of family gives the name A to the baby. She was born in Turkey, and by her biological mother, she was sold in exchange of money. The victim's story is that she is of Afghani national. M and D were married in Afghanistan, but they could not have children, and they come to Istanbul, and M wanted to have a baby, and she says rather than the Afghani person becomes or gets an abortion when she's pregnant, she says, in exchange for money, and rather than you having an abortion, give me the baby and I will cover the costs, M says. And the date of birth, on the date of birth, they go to the hospital, but the papers, in order for the papers to be arranged, that the document that the birth was given by M, the arrangements are made at the hospital by M and N, and M leaves the baby and gets the money, and M and N do not come together again. 5 months later, M goes to the family health center in order to have the checks of the baby. But due to the care of the family physician, the physician remembers that M could not have children due to her physical conditions. He notifies the relevant law enforcement officers. They say that M also, that the baby needs to have an ID card, and M is guided or referred to ASAM, the Solidarity Association with Migrants and Asylum Seekers, and they want the records to be also taken by UNHCR officials. The officer in Assam checks the records and sees that M and D cannot have children due to their physical conditions, and they notify the situation to the Provincial Directorate of Migration and says that they should go to Provincial Directorate of Migration Management to have ID card prepared. But M says that since the child may be confiscated by DGMM or PDMM officials, they didn't want to go to PDMM. But when the association officers say, I talked to them and there won't be a problem, they go to PDMM, and once they go there, directly the law enforcement officers are informed and a decision on protection is obtained, and they are the baby is put into a shelter, and then identification is made. Is it the last case? Yes, that was the last case. If you allow me, I want to make an assessment. Let us make an overall assessment, but there was a reason why I showcased these cases. In order for raising awareness, this summit is a very important opportunity. And Mr. Tommaso, when he spoke yesterday, he underlined a few issues about unaccompanied children. Why do unaccompanied children come here? Who brings them here? This needs to be assessed, he said. We also do believe that unaccompanied children should also be protected, and since these two cases are under vulnerable situation, we have identified some solution offers for them. For unaccompanied children under international protection, they are of course assessed, and due to the workload, well, actually in our law there is no such arrangement, but due to high workload and they cannot be deported, there are no interviews for deportation for them. This can be postponed until they reach the age of 18, but when they reach the age of 18 or until then, they run away from the shelters or they cannot be found. And in order to identify the victimization of children on time and effectively in our law, there's a very nice article, paragraphs Ch and G. There is a non-refoulement arrangement, and maybe there could be an arrangement for unaccompanied minors. We can identify their vulnerability. The second case, as you know, the residence permit for victims of human trafficking is provided for 3 years, and after 3 years they could be put under different types of protection. They can be considered as unaccompanied minors or in other forms. So as far as we know, they can be subject to the provisions of unaccompanied children. However, this child right now is staying with foster family, and the foster family applies to the court to adopt this child. But since the child is not a Turkish citizen, this child could not be subject to adoption, the court says. So the babies who are or children who are subject to human trafficking, we believe that there could be we could have a proposal of providing them Turkish citizenship. Thank you very much for your patience and attention. Thank you very much, Kübra. You have shared your valuable experiences with us. This was a very fruitful presentation, but due to limited time, we couldn't give you much of time. Apologies for that. And now from UNHCR, we have Miss Ezgi Özenkök, and she is going to talk about the activities and guidelines of UNHCR on this field. Thank you very much. I would like to extend my regards to all distinguished participants. As UNHCR in Turkey, regarding international protection and its linkages with human trafficking, our first path, actually we have more than one ways forward for that. First, of course, the main basis for UNHCR is the Convention of 1951, and also the law on foreigners and international protection is another basis for us. Another relevant legislation is the basis for us. But as well as this, we have the guidelines number 7 about international protection, and in terms of the Convention 1951 and the protocol of this, the supplementary protocol of this convention is the topic of a document of UNHCR in the format of guidelines. As I specified yesterday, the linkages between human trafficking and international protection, UNHCR's opinions are laid down in this document, and in terms of identifying international protection procedures, this document actually shows the methods. There are some principles and a couple of recommendations for the decision makers in this document. Well, first, this is not something specific to this document. This is also underlined in our law. The human trafficking victims might be in need of international protection, and in these cases, facilitating the access of these persons to international protection should be considered, and steps to allow this should be taken as soon as possible, and that should be facilitated. Apart from that, the people who are identified to be in need of international protection or who have applied for international protection, non-refoulement principle should be followed. This is relevant both under Article 4 of the law on foreigners and international protection, and this is stipulated in the nature of the Convention of 1951. As well as that, as mentioned by Mr. Emre, of course, every victim of human trafficking cannot be assessed in the scope of international protection, and this is not required. For a person to be considered in the scope of international protection, there should be a legitimate fear of persecution. However, the guidelines tell us and warn us in the sense that kidnapping, raping, sexual slavery, forced prostitution, harvesting of organs, or prohibition of access to medical care. These are also considered as persecution factors. Also, the guidelines tell us that 1951 convention has 5 justifications or 5 causes. So with these 5 justifications and the linkages of the reasons of the people, when there are linkages, even only when the people are victims of human trafficking, this linkage can be established. As Talib mentioned, this could be belonging to a certain communal group or a certain social group. So there could be a direct link with this social group to international protection, and there might not be any additional linkages necessary. In the guidelines, again, another important issue is stateless persons. Identifying the stateless persons and their procedures have also been identified in the law on foreigners and international protection. Not only in terms of being a refugee or conditional refugee, stateless persons, that possibility should also be considered. Apart from that, the main principle is to keep confidentiality throughout this process, and the best interest of children should be taken into account. These are all laid down in our legislation as well. So from these basic principles, from national legislation and international legislation, based on all of these, we are working in Turkey, and DGMM's International Protection and Human Trafficking Department's coordination between us, and we are supporting their work and relevant coordination, and we are carrying out certain activities to strengthen their activities in 81 provinces. So what have we done so far? Well, we created interview techniques handbook together with the GMM. Interview is very important. It's a very technical area, as mentioned by Mr. Talib, and as underlined by other speakers on different panels and sessions, people under trauma to express themselves is not always easy. And in that sense, while communicating with these people, we should have some level of expertise, and we should be aware of the existence of certain interview techniques and tools. That is why interview techniques handbook would be useful for everyone working on this field. As well as that, in terms of the linkages between human trafficking and international protection, we are carrying out training activities. Under national and international legislation, basic principles are conveyed in these trainings, and also there are case studies regarding countries of origin. In order to understand the procedures and needs, there are questionnaires and surveys that are carried out. The questionnaires contain 27 questions. The people who are working in the field of human trafficking in the provinces, when we ask them about the types of cases, about the nationalities of the possible victims of human trafficking, are all in the scope of the questions in these surveys. And as a result of these surveys, we carry out online and face-to-face provincial visits to understand the practices on the field. Finally, again, in cooperation with the Department of International Protection, as mentioned by Mr. Talib, decision centers and mobile team projects are also supported by us. And if there's anything else we could be of help, if there's anything else we could provide support, we would be happy to offer our support. Thank you very much. Thank you very much, Ms. Ezgi. In a very short amount of time, in a very compact manner, you talked about the relevant activities of UNHCR on this field. Thank you all very much for your patience. The program was delayed a bit. We apologize in this sense. Your valuable participation is very important for us. We have underlined the importance and necessity of cooperation and coordination. Was already underlined in the last 2 days. The academicians, the relevant officials shared their opinions for the last 2 days, and this is a roadmap for us as DGMM. And as a result of this meeting of 2 days, as far as I know, there's going to be a document that will be prepared, and these recommendations here will be laid down as a plan, and if necessary, it will be turned into a strategy plan. Thank you all very much for being here, and have a good evening. Yes, in our last session, we would like to thank the moderator, Mr. Kurt, and our panelists, Ms. Roagna, Mr. Çölyen, Mr. Menekşe, Ms. Özcan, and Ms. Kök. Thank you very much for your contributions. For 2 days, we have witnessed very important speeches, and this is the end of the summit on combating human trafficking. And in the scope of the action on strengthening the human rights protection of migrants and victims of human trafficking in Turkey, we hope that this summit was useful and beneficial and fruitful for all of you. Have a good evening, everyone.